6:45. It is the meeting of the Board of Adjustment, Wednesday, August 17th. And will everyone please rise for the Pledge of Allegiance? Okay, and Mr. Shields, would you like to lead us?
Absolutely.
Right up here. They moved it.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. And may we have a roll call, please?
Chairman Philippe,
Here.
Board Member McDermott, Board Member McDermott,
Present.
Board Member Pierre Lewis, Board Member Shields,
Here.
Board Member Williams.
Present.
We have quorum.
Thank you. And can we please do the announcement to the audience of the process for this evening?
Good evening. This is a summary of the procedures applicable to quasi-judicial items, which would be all of the items on tonight's agenda. These rules apply to applications concerning specific parcels of land like variance applications and special exceptions. The board will sit like a court, hence the term quasi-judicial, reviewing the facts presented at the hearing, applying the adopted rules as explained by staff in the staff report and verbally. Board members can make site visits but must disclose the evidence upon which they intend to rely from that visit. Board members will disclose at the beginning of the hearing whether they have had communications with individuals on behalf of the applicant or otherwise, including who the communication was with and what the topic of discussion was. All persons intending to speak to the board will be sworn by the clerk. Staff will make a presentation and the board may ask questions. The applicant will then make a presentation, including expert witnesses, if any. The board may ask questions. When the public hearing is open, the public can make comments on the application limited to 2 minutes each. Citizen testimony must be fact-based, not opinion. The board then deliberates based upon the evidence presented. The board's decision must be based on competent, substantial evidence, meaning based on the record, staff presentations, expert presentations, and fact-based comments by citizens according to the standards for approval set forth in the City Code. The board may then approve, deny, or continue the item. While staff previously read into the record emailed comments, we have concluded this is improper in quasi-judicial matters, as the person sending the email is not sworn and there is no opportunity for questions or cross-examination. Written comments provided before the meeting are made part of the record and were made available for review by commissioners. Lastly, we ask each of you to treat this proceeding with respect and proper decorum, no calling out, interrupting speakers, or disrupting the proceeding. Please give this proceeding the same dignity as if you were in court. Disruptions are prohibited and enforceable pursuant to the City Code. Thank you.
Thank you. And with that, anyone who will be speaking on an item tonight, we need you to stand and take the oath.
Please raise your right hand and repeat after me. I solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth.
Thank you.
I'd like a question.
All right. Any amendments to the agenda? None. Okay. May I have approval for the minutes of June 15th?
So move. Second.
It's been moved and seconded. All those in favor say aye.
Aye.
Any opposed? Nay. Communications, and I know we'll do communications per case. Okay. All right, and we will begin with the any continued petitions? No. New petitions. V-08-22, variance to legalize an existing non-conforming accessory dwelling unit, 1430 Northeast 138th Street. And Mr. Cook will go ahead and make it the presentation.
Good evening. I'm Derek Cook. I'm the director of the Planning, Zoning and Community Development Department. We apologize this evening that our monitors are not working because of an act of nature that happened a few days ago, so they are out. The item that we have before you is a variance request pursuant to Article 5, Division 1, Section 5-102 of Chapter 29 of the City of North Miami Code of Ordinances, Land Development Regulations, LDRs, to allow a detached accessory dwelling unit, ADU, one on the lot smaller than 12,500 square feet, two, that exceeds the maximum of 25% of the principal residence, and three, with a design and color that differs from the principal dwelling unit on the property located at 1430 Northeast 138th Street in the R2 zoning district. Said variance is to be reviewed under the criteria set forth in Article 3, Division 6, Section 3-606 of the Land Development Regulations. I would say you can see the item, but you can't see the item. So what we have here is the applicant is requesting a hardship relief through the variance process to permit an existing additional dwelling unit on the subject property. The property has no open code violations. It is noted that the ADU in question was first identified in October of 2020 when the property failed to get a reoccupancy inspection. The request is pursuant to, as stated, to Article 5, Division 1, Section 5-102 of the Land Development Regulations. The applicant hereby seeks a variance to permit an existing additional dwelling unit on a lot smaller than 12,500 square feet to exceed the maximum floor area of 25% by 33.6% of floor area of the principal dwelling unit. That is, that you have the principal dwelling unit, your ADU cannot be more than 25% larger than what the floor area is for the principal dwelling unit. You have two criteria. You have to have a minimum of 500 square feet or no more than 25% of the principal floor area. In this instance, the applicant has a dwelling unit detached that is more than 25% of the floor area of the principal structure. And the other element of the variance is that in the code, the ADU must be in a characteristic that is similar to the principal structure in design and color. This item is not. It is two-story. The principal structure is one story, and the colors are different than what the principal structure is. So they are seeking three variances. A variance, you have to have a minimum lot size of 12,500 square feet. The applicant does not have that. They have an ADU that is more than 25% of the floor area of the principal structure, and it does not coincide in design with the principal structure. The property to the north of Northeast 138th Street is a single-family home. To the east, you have single-family home. To the south, single-family home. And to the west, a single-family home. So you're in the middle of a well-established single-family home residential area. As stated before, the property is zoned R2. The parcel in question is approximately 10,425 square feet. And as stated, it is the proposed variance is to legalize an existing additional dwelling unit. So you that are watching on television, you can see these are pictures of the property. You have the principal residence to the upper west corner of the property, and you have to the lower west corner, you have a picture of the actual additional dwelling unit, and you're showing both of them as it coincides in the rear with the principal property and the additional dwelling unit. So in our analysis, we look at 6 criteria associated with the review of a variance. And to get a positive recommendation from city staff, the application must meet 4 of the 6 criteria. And the 6 criteria consist of one, are there special conditions or circumstances exist which are particular to the land, structure, or building involved and which are not applicable to other land, structure, buildings in the same zoning district. In the instance, we say no. There are no special conditions or circumstances which exist particular to this land, structure, or building involved. Second criteria is are there unusual circumstances or conditions necessitating the variance request? Are they present in the neighborhood, and are they unique to the property? No again. There are no unusual circumstances or conditions necessitating the variance at this property, or nor are there any unusual circumstances. However, it is noted that the city staff performed a desktop analysis and found 5 other unattached accessory structures that would appear to meet the size requirement of an accessory dwelling unit. While the status of the surrounding unattached accessory structures cannot be confirmed, it is important to note that the circumstances or conditions of the existing ADUs necessitating the variance request may be present in the neighborhood. That is to say that this is not out of character. You have other accessory structures that exist in the neighborhood that are similar to this one. Maybe not in height and things like that, but they are there. So it wouldn't be out of character to have it here. It's also important to note that the code does identify, and I get to that later in the analysis. The third criteria we look at is, does the request that variance maintains the basic intent and purpose of the subject regulations, particularly as it affects the stability and appearance of the city. In this aspect, the staff says yes, and that the basic intent of Section 5-102 is to promote and encourage the creation of legal detached accessory structures and units in a manner that enhance the residential neighborhood and helps residents meet their housing needs and realize the benefits of an accessory dwelling unit. The requested variance seeks to legalize the existing non-conforming detached unit in a manner that will not negatively impact the appearance of the neighborhood or the city. The requested variance affects the subject property, and given the setbacks and height complies with the R2 district, it does not pose a perceivable negative impact to the surrounding area. 4, does the literal interpretation of the provisions of the LDRs does the literal interpretation of the provisions of these LDRs would deprive the applicant of the rights commonly enjoyed by other properties in the same zoning district under the terms of these LDRs? No. So what are we saying here? Does granting this variance or not granting this variance prevent the applicant from being able to use the land? Prevent the applicant from having a single-family home there? No, it doesn't. It just means that they wouldn't be able to have this accessory dwelling unit if the variance is not. So it doesn't take away from them something that is already existing in the neighborhood, which is a single-family neighborhood, and that's what they have there. They're seeking the additional accessory dwelling unit. And 5, the variance requested is a minimum variance that will make possible the reasonable use of the land, structure, and building. In this instance, staff has said yes in this capacity, that the requested variance will allow for the applicant to legalize the existing non-conforming accessory dwelling unit. Without the variance, the applicant will be required to demolish the structure that was not built by the applicant to meet the LDR's minimum setback requirements. According to the staff opinion, the most reasonable use of the structure would be through a legalization through the LDR, through the Board of Adjustment. And 6, the granting of the variance will be in harmony with the general intent and purpose of these LDRs, and such variance will not be injurious to the area involved. We say yes here. Most specifically, the requested variance is to legalize, as saying, an existing non-conforming accessory dwelling unit constructed without the building permit around 1990. As per the Miami-Dade Property Appraisal website, that is the date of the construction. This process will allow for the property to be reviewed by the building department and permit to be issued for the non-conforming unit. Furthermore, the conditions of the approval will ensure that the occupant restrictions of the ADU within Article 5, Section 5-10, E, and 8 are upheld to protect the stability of the neighborhood and the area involved, as well as ensuring that the accessory dwelling unit serves as a housing need for the city. So I'm going to go into that more specifically in the conditions. What this is doing is the city, as we know, we have a crisis with housing in Miami-Dade. So one of the initiatives that came up some time back in trying to address our housing need was to allow for accessory dwelling units within the city. And also, as a part of that legislation, you have criteria that it must meet a certain income bracket, that they must be low income, middle income, certain years, and they must do a restricted covenant to tie them to that. So that's why when we introduce this ADU process, that we look at it as a means to trying to help our housing crisis, to give people opportunity to live in an affordable environment. So with that in mind, staff recommendation is that pursuant to Article 5, Division 1, Section 5-102 of the Land Development Regulations, the applicant hereby seeks a variance to permit the existing accessory dwelling unit, 1, on a lot that is not 12,500 square feet, as you know, is slightly more than 10,000 square feet. 2, that exceeds the minimum 25%, maximum minimum 25% of the area, either 500 or 25% of the floor area of the principal structure. They exceed that. 3, that is in a design that is not coinciding with the design of the principal structure. Staff finds that the requested satisfies 3 of the 6 requirements. In light of the findings and the nature of the request, staff renders no recommendation to the board. However, if the board elects to approve the variance request, staff recommends the following conditions to be included. So this is extensive. This is specifically from the LDRs as it relates to accessory dwelling units. If you wish, I can read them into the record, or we can say what is the conditions here would be taken into record. It's up to you, the board, if you want me to read the conditions into record.
What's the board's desire? Mr. Shields?
In the interest of time, could we read them quickly? I mean, I know there's quite a few of them, but
It's in the
just-
staff report.
It's
He can
in
just
the
adopt the
report.
staff report at this point.
okay,
Okay.
no worries.
You can just adopt the staff.
Yes, we're still, okay, adopt the staff report as presented, if that's clear with you.
Madam
That's my
Chair.
presentation.
Okay.
Mr. Hill?
Our attorney had something.
I wanted to offer some alternative explanations in addition to staff. I've discussed this with staff this afternoon. And actually, you might want to swear me in, so if you can give me the oath.
Please raise your right hand and repeat after me. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do. Can you hear me okay? Or should I-
we can.
Yeah, okay. So, well, I'll do this. So, 2 factual points to make based upon the evidence that's in the staff report is that, so the maximum permitted square footage of the dwelling unit would be 25% of 2,698, which is 674 square feet. But if you look at the footprint of the two-story structure, it's actually less than that. It's 528 square feet, which is less than the footprint of what would be permitted under the code. So then the question is, how do you treat the two-story? And that has fallen under the design. There were two design comments by staff. One was the color, and I suggest to you a building can be repainted instead of demolished if you accept a change in color. But the two-story, that actually both structures are rectangular CBS structures with pitched tile roofs. So they are actually very similar in design, in my opinion. So you can, if you were inclined to approve the item, you could add a condition that the ADU be repainted to match the principal dwelling, or that the principal dwelling be repainted to match the ADU. So the colors are in line with each other. As to the criteria of evaluation, as to number 4, seems to me the property owner is penalized by having an ADU before the regulations were adopted. So he or she would not have known about the 25% rule or whatever when they were designing this. So I think the literal interpretation of the LDRs do deprive the applicant of rights commonly enjoined by other property owners who had notice of what the regulations would be. So just an alternative way of looking at some of these facts and issues.
Thank you.
Thank you.
I just have, before I call the applicant, I just have a couple of questions for Mr. Cook, because in your presentation and what I read, number 1, this was built without permit. So how do we know that it is sound structured, it is a sound structure and meet what we require in terms of the building itself? I know it's been there since 1990. Thank goodness we have not had a big hurricane or anything like that. And my second thing is, I saw that it was identified as a violation in 2020, but yet it was moved in terms of it changed hands. So what happened along the way for this that brought us here? I don't know.
So the first question I would say, Madam Chair, is that if you also deem to allow for this variance, as part of the reoccupancy, they would have to go through building department and the building department to do the inspection to ensure that it meets structural soundness. As for the second question, I'm not sure what happened with the violation. It changed hand. What we have now, you have the current owner recognizes the situation. They want to legalize it, so they have come to us through the variance process to legalize it so it can operate freely within the city without any cause for any further violations being issued against them.
Thank you, Mr. Cook. I have an additional question. Have you or staff done any analysis on what the cost of demolition of an ADU in general, or maybe in perhaps of this size, might be?
No, sir, we have not did an analysis on the demolition costs.
Okay, thank you.
I'll hold off until I hear the applicant in our usual discussion. Is the applicant present? You can use the other mic. Please state your name and address.
Jessica Castellan, 18. Oh. Jessica Castellan, 1825 Ponce de Leon, number 165, Miami, Florida 33143. I'm here on behalf of, I'm the applicant on behalf of John Juan Reyes. Basically, he purchased the property.
Are you an attorney? Do you have power?
Yeah, power of attorney. I had submitted all of that, yes.
Okay, thank you.
Basically, he purchased this house in 2021. I have the certificate of reoccupancy, which was given, which basically says it was a detached garage converted to a studio with new windows. Obtain all required permits, or buyer can apply for a conditional certificate with the city of North Miami. So when I went to submit the permit for the structure, they basically said, oh, you need a variance. So the reason we're here is so that he doesn't have to spent, like, he thought he was gonna be able to pull the permit, and now we're here. So if he has to paint it, he's willing to paint it, but that way the structure doesn't have to come down. But basically, like he said, it was a structure that was already there. It was a detached garage that was converted.
I'm sorry, go ahead. Yes.
Is the property owner currently under the terms of a conditional certificate of reoccupancy with the city? Does he have money in escrow with us?
That I don't know. I would have to ask that.
Okay.
But I know when I went to pull the permit, this is how it all transpired. And the immediate thing after, if this is approved, is to go with the plans to the city so that it's legalized and permitted.
Okay. All right. With that being said, thank you.
Thank you. Is that
Uh,
it?
I have a quick
Sit
question.
down?
Let's try to do public hearing. If there's anyone in the public who wishes to speak for or against this item, this is your opportunity.
Hi, good evening. Jeanette Baez. I am a property owner at 925 Northeast 129th Street. I would actually like just to point out some of the points that were made with regard to the additional structure. I would like to speak in favor of it simply because if it withstood, it was built in 1990 and it withstood Hurricane Andrew, which was built in 1993, then we can hopefully say that the structure at the very least can withstand a hurricane of that magnitude should it hit again. That's all I have to say on the matter.
Thank you. All right, I'll close public hearing. Board discussion. Yes, Mr. Shields. On the item, sir?
This one, Philip Cookers, 985 Northeast 129th Street. These neighbors have spent so much money fixing up the front of their house. They put in a fountain. They have the most beautiful rocks. You were talking for someone else. I'm sorry. I thought I was talking. Mike, I'm sorry. I thought they were going to come. I'll be back.
Okay. All right. Public hearing is closed. Go ahead, Mr. Shield. You had a question
I mean,
for
for-
the applicant or for Mr. Cook?
For the applicant.
Okay.
And for what it's worth, based off this picture, I mean, the front of this house looks pretty nice too. I mean, no fountains or anything, but looks nice. Very quick question. What is the current and also proposed use for the ADU? Apologies if you might have already stated this, but just to kind of restate again.
Like, he currently has it, I know, empty on the bottom, I think. Like, it's just, if you see in the pictures, it's just, he's using it as storage, because it was a detached garage.
Okay. And will
In the top.
in the top?
And the top, I don't know if it's a family member or if he's renting it. I don't know if you can confirm that. Not at the moment, yeah,
Okay. So it's not occupied at the moment?
no.
Okay. Thank you.
You're welcome, thank you.
I will ask a follow-up question though, just to confirm, but it is intended to be occupied. So you don't have an occupant currently, but the idea is that you would like to have an occupant there.
Correct, because
Okay.
when he purchased the property, it was assumed that that's what it would be used for.
And I think you just said this, but I just want to clarify. So
course.
right now he's using the bottom part as storage.
Like,
Is-
that's what it looks like, because it's just like it's just some stuff there. He hasn't cleaned it up yet because he wants to make sure it's like permitted, and then
So there wouldn't be a world in which you're renting both the top and the bottom out. So like would the top and bottom have tenants ideally,
It
or is it
could-
just the
it could
top?
ideally, yes, it could fit both, yeah.
Got it. Thank you.
You're welcome, thank you. Anybody else?
It would have to be one unit.
I'm sorry, we've closed public hearing for this particular item. Okay, any more questions for the applicant?
No, but I think there's some.
I have a question for Mr. Cook. I'm trying to understand, I know the city came out with this whole granny pods or whatever we want to call them, and the purpose was really, from what I understood, to assist property owners if their family become like you're adding a baby, something like this. Was the law made
So
in
if I
order
may-
for property owners to be able to rent out?
Yes, ma'am.
Huh.
So the criteria
In every residential area?
in the R1 and R2.
Thank you. No,
Madam Chair?
thank you.
So if I may elaborate on that, Madam Chair, through the chair, if I may. So
ahead.
you would look at it in R1 and R2, why that would be applicable, because you only allow for single-family homes in those districts. When you get into the R4, R5, or 6, they allow for multifamily, so you would be able to have, if your site allows for it based on the density, 2, 3, 4 units there. So,
Madam
Okay.
Chair? Mr. Cook?
yes, sir.
Knowing that the possibility exists that they are going to use both the bottom and the top as rental units, and we don't know how many people will be in those rental units, does that change your analysis?
It's the only thing they have to deal with as it relates to that, if do they have the parking necessary
Well,
to
that's what
subsidize for
that's
that.
what I'm saying.
Yeah,
If you're going to
yeah.
be renting out
An
both
additional 2
both of
cars.
those units, you're going to be faced with that old parking situation that we
We should, yeah.
have to deal with all the time. So, yes, Mr.
If you were to approve it, it should be clear from the conditions that only one ADU is permitted, and if they rented out the bottom and the top, it would have to be to the same people. Treated as one unit.
Mm-hmm.
Yeah.
Mm-hmm.
Yes.
And
So we could actually attach two, we could ask them to repaint it, obviously, and it does look a little shabby. And we could restrict them to only having one renter in the facility.
Yes, but it could be both top and bottom.
Yeah. Okay.
And I suppose they could also, the owner could use the bottom and rent the top if they were split.
So he could rent either one, but
Right.
not both,
He could rent both, but to the same person.
to the same person, yeah.
Right.
Chair,
And any other discussion? Well, and I still have question. I'm sorry.
permission to clarify.
Mm-hmm.
As per the conditions, which is taken straight from our code, the occupants of the ADU shall not exceed 2 persons.
Okay.
So that is just an effort the code is put in place to limit the concern of having multiple units.
Oh, okay.
I do have
We
a few
open
comments,
up
but
a-
I'll wait for your question.
Yeah, and I did believe back then that we opened up a can of worms, but I still believe that. But let's not go there. What I wanted to find out, you said they'll come in and they'll go through permitting and all that. I get it. I guess maybe explain to us what, because at some point, who pays or who is made what's the word I'm looking for? An example so that these things stops happening. Because this is a building built without permit. So I'm pretty sure the person who did that sold his property and got much, much more money for it because of this structure. We didn't know about it, but they made a change to Miami-Dade County property thing. So now they benefited, but yet we've still got to deal with this mess. So what happens?
Excuse me, Madam Chair. Forgive me. I'm not clear of your
sorry.
question that you're asking me. I'm sorry. Forgive me. So, I don't know what happens as it relates into the holistic, I think, level that you're speaking of. What are we doing to try to curtail these illegal units from in the city
It seems
and things
like
like
tonight
that?
is all about
and I think maybe on the other side of that, you are alluding to, even maybe to a sense by depending on what the board chooses, they choose to grant this, are we encouraging such activities to take place in the city? So that said, I would say what we were having, as you would spoke of and was mentioned of, was that they had a citation in 2020, and that is the mechanism that we have through code compliance, of going out, seeking it, and citing people for this. And then the question would come up then, if it's a legal unit structure, how would they go about curing it? And the cure would be this variance process potentially.
Yeah.
Or
But how
if,
did
if they
the-
meet all the criterias, then they may not even need to go through it. If they're in the R1 or R2, they're in a site, they're on a lot that is more 12,500 square feet, that the unit is at least 500 square feet and no more than 25% of the floor area, then it's something that they can just do through an administrative process with the city, and then building and stuff like that, make sure it meets all of the building code requirements.
I have a quick follow-up to your question, Madam Chair. So, most of the suggestions that are in the record, in order for staff to recommend this, or in order for the board to recommend this, if we chose to do so, are involving this being occupied by renters. What if this instead is occupied by the family of the applicant or future families and not renters? Are there any type of policies or procedures in our city and zoning planning and zoning that could cure this issue in the future? Like, for instance, one of the things I'm thinking about is, if this is, just to clarify my question, if this was rented under, and we were to approve this, right, under Chapter 5, Article 4 of the City Code of Ordinances, obviously you all are going to make sure that this meets minimum housing standards, which would make sure that it's a safe structure, ensure that it's at least has safe and sound architectural design, etc. My concern is, what if this isn't rented? Are we still protected under our city code to make sure that this still has minimum housing standards?
So the process that we're going through tonight is to legalize the structure. Irrespective if they rent it or not, if you decide to grant them this variance to legalize it, they still have to go through the reoccupancy process, because now it's a structure and it now has to be reviewed that it's a sound structure that meets building permitting process. The second part of that, or the other side of that coin, is if they're going to rent it, then there's certain criteria that we have set forth that they need to meet to be able to rent. And those criteria are that it either is a senior, 55 years or older, it is extremely low income, very low income, a low income or moderate income person, and that they would have to do an affidavit, a covenant, to confirm that the person that they are renting it to meet those criteria. And they would need to get a business tax receipt with us, and they would need to get a certificate of use, because they're functioning as such as a business.
And we may say all of that, it's wonderful, but how do we enforce it? You know, because once we grant it for what it is. And unfortunately, I know they may not rent it to someone, but even thinking, and I'm not saying that's what they're doing, but we all know that we don't even allow Airbnb in our city, but they're all over. You know, and I don't know.
If I can add a quick comment there, based off of what I see from staff's analysis here, that in order to receive the certificate of use, the applicant would have to obtain, or essentially have an approved affidavit showing all the items that Mr. Cook just mentioned, which is that it's limited to the property owner or seniors 55 and over, and those qualifying as extremely low income, very low income, or moderate income. And further, there's another piece here that under that same affidavit, that would have to be filed annually, that the property owner, if renting, would have to show a minimum of proof of income and all, for the of the tenant,
Okay,
and other items such as Social Security annuities, retirement funds, disability, etc., in the form of W-2s or other forms.
I'm glad you delved really
Not
into
trying
the
to speak for staff here, but
Yes.
at least just quoting their own analysis
Okay.
for our recommendation.
You know, our part of the discussion, you know, our job here tonight, or what we're being requested to look at, is whether we're going to authorize this
Yeah.
Adjacent unit. Is there any? I mean, we could simply authorize a unit, but restrict them from renting it, or you know, it could be an adjunct unit for whatever, storing of boats, cars, whatever, etc. You know, if the concern is enforcement, then we could let them, you know, approve the unit and, you know, and restrict them from renting it, or perhaps even just one, you know, one floor. I hate to say one tenant, because I know right on 131st Street, there was one tenant that rented 2 pieces of property, and there's probably like 20 people in there. So just saying, you know, to just one person is not, it doesn't really prevent what the chairwoman is speaking about. You know, and there's no enforcement, you know, so that's the other issue.
Well,
So, but the question that I have is that although there's no enforcement, that's not for us to deal with here, though, right? Like, we are
We
simply,
try and preempt
We could make a
that.
recommendation
We can make
Okay.
for what
recommendation.
enforcement would look like,
Yeah.
that's fair.
which
Okay.
staff is
Yeah.
recommending.
Okay.
Yeah, if we were to vote upon this.
yeah. And at this point, I think we've got something, we just want to make sure that it's safe, and the only way to do that is to, I guess, other than level it, is to make sure that we approve and then attach all these requirements so that the city gets in and do their analysis and make sure that everything is up to par.
Madam Chair.
I'm sorry.
No. As to Mr. McDermott's comment, it seems like the restrictions are almost to encourage a policy of providing senior and affordable housing.
Right, well, that's
So
what it is intended for,
eliminating
yeah.
that opportunity, you know, restrains that policy.
Okay.
So, if I may, just to kind of move this along here, a couple of quick comments and then a recommendation for us as we consider voting on this. So, my first thought is this. I mean, is 2022 similar to 1990? We also have an affordability crisis. And unfortunately, it ain't going anywhere. And we have to do something about it. Second, on top of that, we are in a technical recession, whether people want to say it or not. And I have a concern thinking about precedent here. If we vote down on this, and all of a sudden this resident and many others would have to pay for demolition of an ADU built in 1990 before you even purchased the unit, before you even purchased the residence. And, you know, me as a real estate professional, I know that that's going to cost upwards of $30,000+. Yeah, just as a fact here. So that's a concern of mine. On the other hand, another concern of mine is I certainly don't want to encourage the construction of new ADUs in our city. I think we need much smarter, efficient, and effective affordable housing. New construction of multifamily units in our city and granny units is not going to cut it for solving our affordability needs. But I certainly don't want to admonish an applicant here for a structure that was built prior to them buying this property. I also want to make sure that the structure itself is sound, and especially given that it's 32+ years old, for future either residents, tenants, or the property owner himself, or future folks who may own this. So here's my recommendation. My recommendation is that we move to approve this under all 9 of staff's recommendations that are in the record. I will not read them because they're 2 pages long. But just to briefly summarize, it essentially states that the tenant can have no more than 2 persons occupying the ADU, to your point, Mr. McDermott, that if rented, it has to meet all minimum housing standards by the city, which would also include that the owner files an annual affidavit showing proof of income and various other items that a multifamily renter would, that same standard would have to show for tenants, and also would have to have a certificate of use and business tax receipt approved by the city, and further that that certificate of use is essentially for affordable senior purposes, which is for folks aged 55 years or older who are extremely to moderate income. I hope I did justice in the summary.
Thank you, Mr. Shield.
I'd also add to that one other recommendation, that the property be painted to match to match the main unit within the single family residence.
Okay. It's been moved by Mr. Shields. Do I have a second?
I'll second.
Seconded by Mr. McDermott. All right, roll call.
All right. Chairman Philippe,
Yes.
Board Member McDermott,
Yes.
Board Member Pierre Louis,
Yes.
Board Member Shields,
Yes.
Board Member Williams.
Yes.
Motion approved.
All right.
Congratulations.
You've been,
Thank you for your time.
yes, tell Mr. Reyes that he's been approved. Okay.
Thank you.
All right.
So we have 9 items on the agenda
Oh, yes,
tonight.
I
on board.
understand.
ADUs are important.
They seem to be interrelated. Okay, next item, V-09-22, a variance to permit a reduced rear yard setback at 330 Northeast 126th Street.
Thank you, Madam Chair. As stated, this is a variance request to allow for a deviation of the rear setback, a variance to Article 4, Division 2, Section 4-203 of Chapter 29 of the City of North Miami Code of Ordinances, Land Development Regulations, LDRs, to allow a reduction from the required rear setback of 25 feet to a proposed setback of 12 feet on the property located at 330 Northeast 126th Street in the R6 zoning district. Said variance is to be reviewed under the criteria set forth in Article 3, Division 6, Section 3-606 of the LDRs. Okay. So as we have here, you have a variance that is related to a rear setback. The applicant is seeking to expand their existing residential home, and in doing so, they are going to encroach into the rear setback. Okay. All right. Oh, excuse me, my
126.
thing is not working. I need to exit. My apologies. Okay, my apologies, something went wrong with it for the television ordinance. So as stated, this is a variance request for a rear setback. The project information is the applicant's requesting that hardship relief through the variance permit to expand the rear, to expand the existing single-family residence dwelling. The property has no open code violations, and pursuant to Article 4, Division 2, Section 4-203, the applicant is seeking this variance to deviate from the required 25-foot rear setback with the proposed 12-foot setback. So as stated in the previous application, you have 6 items that we look at as part of the analysis. This property is approximately 8,925 square feet. As stated earlier, is in the R6 transit zone, zoning district. The proposed variance is to allow for the expansion of the property. This is in the R6. R6 is a multifamily. Matter of fact, it's the most intense multifamily that we have in the city by right. But what we have here is an established single-family home residential area, except for a building that is immediately to the west of the property, where a new multifamily development was built within the last 2 years, which is a 5-unit development that meets the criteria of the district. I mention this information to put some context of what we have here. So we have a single-family home that is in an R6 zone. So with that, you have a non-conforming structure that is legally non-conforming, and they are trying to expand it. So it's going to be a hard threshold to meet staff criteria of a hardship to be able to get 4 of the 6 requirements there, because you have so many factors working against this environment in that, because they're in the R6 zone. So with that in mind, we looked at those criteria as we went over in the last application, and I'm going to go over them again. It's important. So are there special conditions and circumstances that exist which are particular to the land, structure, or building involved, and which are not applicable to other lands, structures, or buildings in the same zoning district? No. Are there unusual circumstances or conditions necessitating the variance request as presented in the neighborhood and are not unique to the property? No. Is the requested variance, does the requested variance maintain the basic intent of the subject regulations, particular to the effects and stabilities of the appearance of the city? So we say no here, and this is why I went into that somewhat introduction about where we are. We're in the R6, so you have a non-conforming, legally non-conforming single-family home in a neighborhood that is established as a single-family home. I'm familiar with this neighborhood because I remember when the applicant who came in for the 5-unit multifamily development in the community was shocked that they was able to build that in that area, because in their mind they are single family, but they are actually R6, and they have an overlay over them, the NRO, which allows for 90 units per acre and a height of 90 feet through the conditional use permit process. So it really was a disruption to that immediate area when this started going on. So when you have that context and you see that this is a single family in a single family neighborhood, but they are not zoned as such, and now they're trying to expand, the question is, okay, you have one criteria they're not going to meet the rear setback of 25 feet. And the other criteria is they have a non-conforming use, and they're trying to expand it, and they expanded it more than 25% beyond what is allowed. So what I'm saying is, in our non-conforming section of our code, for legal non-conforming structures, they are allowed to expand that structure 25% by right if the expansion alleviates all of the non-conformings conformities and brings the property into compliance with the LDRs as extent as practically that they can do it in this instance. So their expansion is more than 25% of their existing floor area, and they're not meeting the setback. But it's a single-family area, and what is that 12 feet opposed to 25 feet is going to have an impact. The use that is immediately to the north of them is a church. Is it a church right there? It's a church, and it's a parking lot right there. So, and let's say if that church ever redeveloped, they decided to sell, the individual who probably going to come in is not going to put a single family there because it's in an overlay district, and it's I think in that area that's actually C1. It's not even R6. So they're going to be looking to do a mixed-use development there, in that. So that's the contextual there. So I say all of that to say it's going to be hard to get to 4. And where we are right now, the staff was only to get to 1 of the elements of the 6 that you need to meet to be able to say yes, that they can, that it meets that. And that is 6 itself, and that is the granting of the variance will be in harmony with the general intent and purpose of these LDRs, and such variance will not be injurious to the area involved. And that is even somewhat of a stretch, because it's R6, and the family, and it's a single family, but it's legally non-conforming. But in other contexts is that it is a well-established single-family home. Will this expansion really be harmful to, would it be injurious to the area? Probably not. But it's not necessarily meeting the intent of the code, because the intent of the code is that you be multifamily in this zoning district. So that's where we are with that. So with that in mind, staff recommendation pursuant to Article 4, Division 2, Section 4-203 of the Land Development Regulations, the applicant hereby seeks a deviation of the setback of 25 feet to 12 feet. City staff finds that the request satisfies only one of the 6 criterias in the requirements, where 4 of 6 is needed to allow for staff to recommend approval for this request. In light of these findings and the nature of the request, staff makes no recommendation to the board. However, if the board determines an action of approval, the following condition or recommendation should be considered for approval. The applicant obtain all necessary building permits and all necessary license prior to commencement of any expansion work. Thank you.
Thank you. All right, is the applicant present? State your name and address, please.
Excuse me, Dexter Chestnut, 330 Northeast 126th Street, North Miami, Florida, 33161.
Thank you. Would you like to add anything to the presentation that Mr.?
Well, the reason that we were looking to expand the property is that I'm moving my parents down here, elderly parents down here, and we want to be able to accommodate their needs right now.
Okay, thank you. That was my question. All right, anything else? Okay, thank you, Mr. Chester. With that being said, I'll open public hearing. Is there anyone in the audience who has something to say for or against this application? Okay. Public hearing is closed. All right, board discussion?
Well, it appears that if this house would, Derek? Where are you?
He's
Oh.
busy.
So basically with the overlay district, if they were to tear this house down, they could build, they could build 90 units an acre, right?
They could.
So in my view, giving them the ability for a small change in setback, particularly with the reasons stated, if they meet all the other conditions set by staff, I don't know. I don't think I would have any objections to it.
Yeah, I agree, especially knowing the area, and I know that building that was constructed and, yeah.
Yeah, so we went through a whole thing last year,
Any other board discussion? Would someone like to make a motion?
Make a motion for approval?
I'll second.
Thank you.
As
Jennifer.
part of the motion, staff only found that one out of the 6 criteria
So
was met,
therefore we
so we're
have
gonna
to
ask for the board to find the other 3 of the 6 criteria to justify granting the variance.
Would you like to? They're right here.
Council? Suggestions?
Yeah.
Well, that's why you and Jennifer get to do the magic.
Well,
I have a question. Can I ask you a
Go ahead.
question? With the second one, the unusual circumstances, since you have this overlay of 2 competing uses, would that
Mhm.
qualify to make number 2 applicable? Could you, if I understood properly?
yeah, what is the overlay, Derek?
The neighborhood redevelopment overlay district, overlay boundary, NRO.
Okay, so I, certainly the board can, decide whether any of these criteria are satisfied by, other means. So if you accept that circumstance is appropriate, then,
I think it.
you can conclude that.
Yeah. Okay.
So, the very fact that this is an established single-family neighborhood in an R6 district, in my mind, means that it should be treated as a single-family district, even though the district is different, and the expectation that it would be redeveloped, should not be something that is highly anticipated. So you can approve this, knowing that it is a unique circumstance that this enclave of single-family homes should be treated as single-family homes. So you can conclude that under number 1, that is a special condition and circumstance, that it is an established single-family neighborhood, which are not applicable to other neighborhoods in an R6 district, in other parts of the city. So, I would suggest, 1 can be considered yes, and based upon Ms. Pierre-Louis' suggestion on number 2, you can conclude that number 2, would be a yes. And
What
How
about
about
number
number
3?
Yeah, I
Yeah.
think that's right.
20 today.
I know.
My thought on number 3 is based off of staff's note that, however, it's important to note that because the proposed addition maintains the single-family use, it will not destabilize the single-family character of the surrounding neighborhood.
Yep.
Okay.
Right. Okay. So you have 4.
Yep.
There we
And my
go.
recommendation, in addition to those 3 changes on the 6 tests, is that we also take staff's recommendation that the applicant obtains all necessary building permits and licenses prior to commencement of work.
Yeah, that goes.
Definitely.
Yeah.
Okay. So it's been moved and seconded.
You have,
Well-
who moved it?
Oh,
did.
Mr. McDermott moved it and Ms. Williams seconded. And roll call?
Board Chairwoman Philippe,
It's okay. Yes.
Board Member Pierre-Louis,
Yes.
Board Member Shields,
Yes.
Board Member McDermott,
Yes.
and Board Member Williams.
Yes.
It's motion moved.
Thank you. You've been approved. Okay? Just don't start work without a permit. All right, next on our agenda, let me make sure. V-10-22, a variance to permit an increase in maximum floor area for a utility shed or other prefabricated structure at 925 Northeast 129th Street. And there are two items. So we'll
Madam Chair,
do them
okay,
separately or together?
Our suggestion to move things along is there are 3 items that have 2 requests, and to handle the hearing together, but you vote on them separately.
Okay,
So I would read V1122 as well.
okay. V-1122, a variance to permit a decrease in the required side yard setback for a utility shed or other prefabricated structure at 925 Northeast 129th Street.
Thank you, Madam Chair. As stated, you have 2 variances for the address of 925 Northeast 129th Street. You have a variance to allow for a deviation in the maximum size to be a clarification of a utility shed, a prefabricated structure, or any permitted accessory structure. And what you have there is you have 2 criterias. If it is a prefab, a shed, it can't be more than 120 square feet. If it's a other permitted accessory structure, it can't be more than 400 square feet. In this instance, their proposed workshop exceeds both of those with a 500 square feet request. Additionally, as a second part of it, just an overview, and then I'm going to read into record the full petition. You have a setback requirement. The setback requirement for the side for an accessory structure is the same as the principal structure. In this instance, the principal structure setback is 14.6 linear feet, and the applicant's seeking 5 feet setback. So, item 1 is a variance to Article 5, Division 5. Number 1 is a variance to Article 5, Division 1, Section 5-112 of the Chapter 29 of the City of North Miami Code of Ordinances, Land Development Regulations, to allow an increase in the maximum permitted area for a utility shed, or other prefabricated structure, or any permitted accessory structure from 120 square feet or 400 square feet to 500 square feet on the property located at 125 Northeast 129th Street in the R2 district. Said variance is to be reviewed under the criteria set forth in Article 3, Division 6, Section 3-606. Second item is a variance to Article 5, Division 1, Section 5-112 of the Chapter 29 of the City of North Miami Code of Ordinances, Land Development Regulations, LDRs, to allow a decrease in the required side setback of the utility shed or other prefabricated structure or permitted accessory structure from 14.6 feet to 5 feet on the property located at 925 Northeast 129th Street and the R2 district. Said variance is to be reviewed under the criteria set forth in Article 3, Division 6, Section 3-606 of the LDRs. So as stated here, you have applicants seeking relief for the one is for the size, 500 square feet, where you have a maximum for an accessory permitted structure of 400 square feet, and you have a setback requirement of the same as the principal structure, in this instance 14.6 feet, and they're requesting 5 feet from the side setback. As you have here, the property is located in the R2. The parcel is approximately 11,360 square feet. It's in a well-established single-family residential area. To the left, to the right, to the east, to the west, to the north, and to the south, you have single-family use. So, some concern has come up with notices that we have received from people, from one person in the area about a criteria that we spoke about in our analysis, where it was referenced that it was other accessory structures in the neighborhood that would make this not out of character. And the individual spoke and said in their letter to staff, said that they felt that it was a misrepresentation of the neighborhood, in that we had not contextualized it within the body of our analysis in this particular way, by identifying those 8 other accessory units that we structures that we have done, what their sizes are or what their setbacks are. So it was like, well, you don't know. So as part of your package and our slide, the exercise was done to look at those surroundings. And that's within the 500-foot radius. The 500-foot radius, which is the notification radius that staff must do when you have variances, special exceptions that's coming before the board. And within that, staff recognized 8 properties that have accessory structures. And of those 8, as you can see on the list, you have 928, 500, 522, 410 plus 240, 621, 475, 672, 515. So as you see with the asterisks were staff letting you know that this was based on a visual calculation using Google Earth. You know, they got that mechanism that allows for you to measure it on those. That's that asterisk. So it's not official. And the other ones are based on what Miami-Dade Property Appraisal says. They are. So the point of that is, one of the criteria in our review is this unique in the neighborhood. Oh, that you don't have an accessory structure that is more than 500 square feet. You have 8 others in the neighborhood within the 500-foot radius. So that's for start. So when staff did our analysis, so as we did with the first 2, you have 6 criteria related to a variance. They need to have 4 of them so staff to be able to give a positive recommendation. In this instance, the applicant was able to get, for our assessment, to meet 3 of the 4. Number 2, the unusual circumstances or conditions necessitating the variance request are present in the neighborhood and are not unique to the property. That goes to what I just talked about. Is you have other accessory structures, what we call it, you can have it either as a prefab, it could be a shed, or a permitted accessory structure in the neighborhood. How they came about, we don't know, but they're there. And you have several of them that are more than 500 square feet. Number 3, the requested variance maintains the basic intent and purpose of the subject regulations, particularly as it affects the stability and the appearance of the city. And this is one that's debatable in the community and stuff like that. And why I say that? Well, you have a setback that is 5 feet that they're requesting. In the code, we allow, through an administrative variance, for people to deviate from that setback to 5 feet, but they exceed that, the floor area that we allow it. Thus, why they're here for the administrative, for not going through the administrative variance, they're going to a board of adjustment, a variance, to allow for this deviation. So that square footage that we allow to be at 5 feet is 100 to 120. So they exceed that a lot. So here we are. So I put that, present that, you know, somebody may have a structure of that size that close to their property line, you know, could be something of their concern. The applicant shows in their site plan on a robust landscaping to help screen it. And you could have as a condition that they must maintain that screening mechanism by fence, landscaping, to help buffer the impact it may have on this abutting neighbor. 4, that's not one of them. And the last one, 6. Granting the variance will be in harmony with the general intent and purpose of these LDRs, and such variance will not be injurious to the area involved. Yes, the granting of this requested variance for an increase of 380 square feet or 100 square feet, depending on which criteria you look at. If you're looking at it as a pre-5, the applicant has not determined if they're going to be a pre-5 building or not, or is this just going to be one of the allowed permitted accessory structures, which is you can do a garage, which is detached, it could be masonry, but it can't exceed 400 square feet. So they're exceeding that. They're meeting that. So in that aspect, they're saying that this shed and thing would not be out of harmony with the area. As we understand, you already have in the neighborhood those existing structures that you have 8 of them, and would this be out of character with the neighborhood? You know, that's relative to how you look at it. You know, you have others who don't have the structures at all. And will it be injurious to the neighborhood? I don't know if it would be injurious to the neighborhood to allow for the workshop. In my opinion, you know, when I saw this, I would say no. But here we are. We have 3 out of the 6. Staff didn't give a recommendation for this item. They leave it in your hands to determine if you feel that this is a variance that they should have as it relates to the size. And as it relates to the setback. So staff also did an analysis on those 8 properties that have it. And you have one that has 10 feet side setback, one has 7, one has 18, one is 0 to 15, one is 6, one is 14, one is 5, one is 6. All of these are by Google Earth, though. These are not official. We don't have a survey that officially delineates what those setbacks are. But even at that level, as many of you have used, you know it gives you, pretty accurate. You in the ballpark. It may not be specific, but you're in the ballpark of what is actually going on there. So the point in this exercise is to let you know that even with those that are existing, they are not meeting that side setback that matches the residential, except that residential is 5 feet, except that residential is 6 feet, 7 feet and stuff like that, and that wasn't the case in these instances. So with that is my presentation. I'm available for any questions.
All right, thank you. Is the applicant present?
Good evening, members of the board. Jeanette Baez. I live at 925 Northeast 129th Street. This is my life partner, Stephen Welty. He also lives at 925 Northeast 129th Street. I've prepared a PowerPoint presentation. I have 7 copies to provide for each of you. Luckily, I apparently predicted there was going to be technical issues, so I printed it.
Think ahead.
Thank you so much.
That's a pretty picture. Not fair.
Members of the board, I am a criminal prosecutor, a civil servant. This is my partner. He is a structural welder. We bought our home in 2018. Both of us purchased this home with the intent to grow it, improve it, and live in it for the rest of our lives. As we bought this home, it was not what it looks like on page 7, I believe. I should have printed a copy for myself. Okay. It is not what it looks like today. The property, we have done substantial upgrades to the property, including we've painted the property, we have increased the landscaping, we have installed and built our own shutters. I personally have stained the wood on the very hot summer Miami days. We have put in new doors, and we've built the majority of our furniture inside. We do this as a cost-saving mechanism. In addition, it also adds to us a nostalgia to all of our property. Throughout 2018 and through the pandemic, we were able to do this successfully because we did not have a toddler in our home. We now have a toddler in our home, and for those of you who are parents, they move a lot. Not only to that, but before we were staining our wood, we were using a lot of chemicals and building items inside our home. We can no longer do that simply because it's really impossible to do anything structural with a toddler inside the house. We have attempted to do some of this work outside. However, the elements of South Florida do not conduce the best environment to, unfortunately, protect the furniture that we want to last us for years with coating and chemicals and paints. As such, we are requesting this variance to build what we're calling our work shed. We do not build any of these items for sale. They are simply for our personal use. In addition, in this shed, we will be building these items. We can actually leave them there so that whatever paint or chemical products we use will not be exposed to the child, and we're also able to put them together there. If you turn to page 4, you will see the shutters that we built ourselves, stained them, and we built them all within the house. Page 5 is a picture of our dining room table, designed, built also by ourselves in our home. And this is our coffee table. Again, and this is our fence. The side setback that we are requesting, this is the page I'm referencing. Sorry, I should have put page numbers on this. So if you look at it from the street view, this is not a situation where this setback is going to be visible from the street. It's not going in any way harm the characteristics of our neighborhood. To the contrary, if you're walking by, hopefully you will see our bougainvilleas and the beautiful structure and the beautiful fence we've built, as opposed to, this structure. So in addition to that, if you look at the following page, our property is actually set back 14.5 feet from the property line. We're actually substantially more setback than anyone else, and as a consequence, this is why it seems almost like it's on the property line, the structure we're trying to build. Let's see. We believe that we should be able to be granted this variance. It is something that we're seeking to continue improving our home, continue the longevity of our home. We do plan on having the landscape surrounding so that the back neighbors, it's not an issue for them. That's our presentation.
Thank you. Would the gentleman like to add anything?
I just have one thing to add. The design layout excuse me, of the home was built in a nature where the property is centered, the structure is centered in the property, therefore it does not allow any detached garage on either side based on the 5-foot offset.
And while I have you there, can I just ask, I know you're talking about all this woodwork. It's not used, well, will you be using, let's say, drills and things like that?
Yes, ma'am.
Okay, so, okay. Thank you. All right. Thank you for your input. I'd like to open public hearing. If there is someone here for or against this particular, welcome.
Good
Please
evening.
state
My
your
name is Philip Cookris, 985 Northeast 129 Street. I've resided there for 63 years. I actually have to tell you how beautiful these people have fixed up their home. The house next to them is abandoned, and the one on the side of them looks abandoned. Their house is the nicest house on this block, except for mine. Anyway, the curb appeal is beautiful. Now, when they bought this house, their wonderful professional real estate agent didn't tell them that 400 feet away from their home was going to be built a 62-unit apartment building. And when I asked them, did your agent tell you? They said no. I'm sure that would have changed what they were planning on, where they were planning on moving. Okay. There are 5 properties that I know of that have actual mother-in-law quarters behind them. There's one behind my house, one next to my house. And I actually, over the years, I'm an agent, I sold 2 of the properties within 1 block of their home that have mother-in-law quarters. We went through all the reoccupancy, we did it all correctly. And I have to tell you something. These people are really nice. They walk their dog by my house every day. We talk all the time. They're terrific neighbors. Thank goodness we have them. And there's another thing that's very important to me, you guys. This guy's retired U.S. Air Force. He's really a great guy. So give him the benefit of the doubt. Everybody's got sheds in their backyards, but a lot of those homes in that area have actual mother-in-law quarters. The two Lassiter properties across from me and next to me, they have homes, places in the back. The house right behind me was monolithic, two structures built in the late 50s, and they were built for the armies. And they had, you know, Keith Richardson had it as a guitar workshop, and now when I sold that property, the man had his mother there until recently when she passed. Give these kids a break. They've really spent a lot of money on that house. It's a beautiful house. I mean, really, it really is. If you see the front, I'm sure you can see. They've got a water fountain in the front. I mean, it's just over the top what they've done for this neighborhood. And believe me, no one else has done anything like them in this neighborhood. Anyway, ladies and gentlemen, give it to them. This is Phil Cooker signing out. Thank you very much.
Sound like a radio announcer.
I want to clap for that too.
All right. I'll close public hearing. Board discussion.
Counsel? So since we took V10 and V11 together, we're going to vote on them separately, correct? Yes.
Your mic on.
Yes. Yes. I said, so we're going to vote on the V10 and V11 separately, correct?
Yes, correct.
Okay. If there's
What-
no comment, I'd like to make a motion.
Okay, go ahead.
Yeah, I'd like, in case number V-10-22, I'd like to make a motion to approve.
I have a question to your motion.
Sure.
Do you have a recommendation on at least one additional item in order to get us to
Yeah.
4 of 6?
Well,
If not, I can maybe help you opine on one.
well,
Do we need it in this instance?
Yeah.
though?
Because it's only one that has been identified.
well, we have 3 that are already identified.
Yeah, it's
We have 3. We
that's
need one
ident-
more.
So
Three?
you have 3, but the
you go.
applicant proffered the last one. If you look at her PowerPoint presentation on the last page, she proffers that her property does have special
Yeah.
circumstances.
Special conditions and circumstances.
Exactly.
Because it's set back so far.
If the board,
Mhm.
To
if the
begin
board was
with.
willing, they could accept.
Thank you.
For the record, when I said opine, that's basically what I was going to say. Was that there is a special circumstance with
Yeah.
this property based off of the setback, which would be, I think, condition 1 of 6. So I'd like to just add to your motion that we are technically considering that yes,
Okay.
that there is a special condition.
All right. Okay.
So are you seconding the motion?
In addition to that, I'll also second the motion.
Thank you.
Really quick question, are we doing this based on the staff's recommendations, like the
Yes.
conditions? Okay,
Yes.
Yes,
okay.
always. Yes.
And we try to follow staff's recommendations whenever we
Sounds like a
So motion has been moved by Mr. McDermott and seconded by Mr. Shields with the staff recommendation and, you know, the criterias that are listed. Roll call, please.
Chairwoman Philippe,
Yes.
Board Member McDermott,
Yes.
Board Member Pierre-Louis,
Yes.
Board Member Shields,
Yes.
Board Member Williams.
Yes.
Motion approved.
Okay. Now the second one.
In V-11-22, make a motion to approve, and we can use the same 4 criteria? Okay.
Mhm.
I second.
All right. Moved by Mr. McDermott and seconded by Ms. Williams. Roll call?
Chairwoman Philippe,
Yes.
Board Member Pierre-Louis,
Yes.
Board Member McDermott,
Yes.
and Board Member Shields,
Yes.
Board Member Williams.
Yes.
Motion passed.
Thank you. You have been approved.
And by the way, you.
Congratulations.
Just don't work
You
too
have a
late,
gorgeous house.
And I hope my neighbors talk about me like that someday too.
otherwise your neighbors will not be happy. All right. Now, the next one, also 2 items. Which is
1001.
SE -08-22, ratifying the status of a non-conforming building at 1001 Northwest 119th Street. Also, SE-09-22, special exception to permit warehouse uses at 1001 Northwest 119th Street.
Thank you, Madam Chair. As stated, the item before you is a special exception use pursuant to Article 6, Division 4, Section 6-401 of Chapter 29 of the City of North Miami Code of Ordinances, Land Development Regulations, to deem the existing commercial building located at 1001 Northwest 119th Street in the C1 District in the year 2022 to be in conformity with Chapter 29 of the City of North Miami Code of Ordinances, LDRs. Said special exception is to be reviewed under the criteria set forth in Article 3, Division 5, Section 3-504 of the LDRs. So, what you have here is part of the request is that you have a property that has an existing 0 setback on the west side of it, where minimum 10 feet is required. And you have a property that has existing 7 parking spaces where a minimum 12 is required. The operation function as a dry cleaner operation as well as a place where you can get propane gas from. I'm sure many of you may be familiar with the location on 119th Street and Northwest 10th Avenue. So the intent of this special exception is to legalize this, make it in conformity with the LDRs. So in doing so, setting that 0 setback is going to be permitted for this property and that the 7 parking spaces would be permitted for this property. And in doing so, by legalizing this, it will allow for them to expand, to build onto the property as they desire to do, is to add a second floor of about 3,800 square feet, which is going to be a warehouse use, if I recall correctly. And that is the nature of their request. So in our analysis, as you can see, surrounding the property, this property is zoned C1. It's approximately 11,285 square feet. And to the east of the property, you have a post office, office use. To the south of the property, you have commercial retail uses. To the north of the property, you have a single-family use, which is non-conforming because that is zone C1. So the single family shouldn't be there, but it is there. And to the west of it, you have a commercial use as well on the property, around the property. So you have criteria that we look at as part of our analysis. And the first one is that we look at is there are appropriate provisions for access facilities adequate for the estimated traffic from public streets and sidewalks so as to ensure the public safety and to avoid traffic congestion. We would say yes, You have two ingress and egress on the, to the property. You have an ingress and egress off of Northwest 19th Street. You have one off of Northwest 10th Avenue. And you have an existing infrastructure where you have the sidewalk that is within, that meets the standard of minimum 5 feet, that is traversed the full property there to allow for pedestrian flow around the property. Are there adequate parking areas and off-street truck loading spaces in the area for the property? No. You have 7 parking spaces that are there. They need 12 for the existing use. The very nature of this application is to allow that to be their standard for this property. I've been at the property. It is a robust activity that goes on at that property. They make it happen. I don't know how, but they're making it happen. Yeah. We say yes in the thing, but in my opinion, you have 7 and you need 12. You don't meet the parking. It is what it is. Is there a suitable landscaping or fencing alongside the lot and rear? There is. They have existing landscaping adjacent to the north where the single-family home is. They have a wall, a masonry wall that is located there that separates them along with some landscaping. They also have a monstrosity building that is there that they're going to get rid of with this new redevelopment. So we'd be glad about that. That's going to help get it. So you have that structure. If you know, yeah, we went out there to see it. It's really going to be a significant improvement by them bringing this redevelopment, adding that floor to it to get rid of that structure that was placed there without building permit. Is the proposed special exception reasonable in terms of logic, efficient, and economic extension of the public services and facilities such as public water, sewer, police, fire protection, and transportation? It's an existing use right now. By us legalizing it through this special exception, it's not going to change those criterias. Will the proposed special exception constitute an appropriate use in the area and will not substantially injure or detract from the use of surrounding property or from the character of the neighbor? No. Special exception is just to legalize what is an allowed use right now. The deviation with this is not based on the use. The use is allowed. It's based on the structures that they have there, the setback, the parking, the non-conforming building that was constructed without a building permit, and you're getting rid of all of that, and it's going to make the site far more improved from what it is right now. So the second criteria is a special exception to allow for a warehouse. So with that, let me go back if I may, please. So staff has recommended approval of this item with this condition, that prior to the commence of the business operation, that the applicant must obtain all necessary licenses and permits, such as building permits, certificate of use, business tax receipt, etc., and must comply with each applicable LDR requirements and city, county, state, and federal regulations. So the second half of this is dealing with the special exception needed to allow for the warehouse use. So when the applicant came to us about this project, for full disclosure, they was just going to say, oh, we want to just add floor area to it so we can have a place to store our propane tanks and things like that. So I said, well, if you do that, that's going to be considered retail space. Retail space is 1 parking space for every 300 square feet. You're already deficient, so you're not going to be able to do this. You'll need a variance and stuff like that. So to mitigate that parking issue, we said, why don't you classify this as a warehouse? Because warehouse parking is significantly less demanding than than the retail area. And what you're using it for is for warehousing. You're just gonna have your propane stuff stored there. So, yeah, let's do it that way. That's what our suggestion was, and that's the route we went, but it needs a special exception. So our thinking was, in doing that warehouse use, you're adding more parking gonna be needed to already a non-conforming. But they are reorganizing the site. If you would look at, I don't know what page it is, where they are adding additional parking to the site to at least mitigate what they had as a deficiency before, adding a couple of more parking. One of it is tandem parking, which I presume they're going to really just have it reserved for their staff to park there. And then it helps at least alleviate some of the pressure that they have with their patrons coming there to get propane and to get their laundry, which is a very active environment, for sure going on there. And they have redesigned it. One of our conditions that we have set with this, as it relates to the site plan, they're showing on the egress that comes off of Northwest 10th Avenue, they're showing in and out. The curb cut is not wide enough to allow for in and out, so they need to have it one way. So either they need to have it as an ingress only or egress only. That was our condition, coupled with the same condition that we had presented for number one, dealing with that they need to get the proper permitting, licenses, certificate of use, and other applicable requirements as it relates to the building of the building. And with that, that's my presentation.
Thank you. Good evening, how are you? Who will be speaking?
Hello, my name is Victor Morales. I'm an architect working with Abdul on this project, as well as a previous project we had done there about 10 years ago.
Just for the
Okay.
record, can we have your address?
Oh, the address.
Yes.
3030 Binnacle Drive, Naples, Florida.
Thank you.
Okay. So I'd like to address the parking issue a little bit, even though we hadn't thought about that previously tonight, just to talk about it a little bit, because if you look, this area right here is where 90%, that area is where 90% of the traffic really happens. What does that mean? This is not a place where you're coming in and sitting there in a restaurant for an hour or whatever. People come in, they get their laundry, and they go. People come in, get their propane, and they go. So, yes, it doesn't quite meet the parking requirements, but it's not the kind of place where parking is that necessary to the operation. It's more of a flow-through. The addition itself that we'd like to do will contain, and I just want to clarify this when it was said propane tanks, they're all empty propane tanks. And what they have been able to do is that it has become a real center of supply for many propane places in Miami to buy the tanks that they can then serve at their locations, other businesses. And that's the need for the warehouse. As well as they have developed a certain amount of trade with people who do welding all around the county to come and buy their supplies there. So that entire second floor, even though it looks kind of tall, it's really one space. Okay, it's really one space, just that second floor. But it's open inside so that you can stack, much like you would see at Home Depot or Lowe's. Okay, and you operate a forklift to move things in around. There'll be a freight elevator in the back. And we did change some of the parking to alleviate, be able to actually, I believe we added 3 parking spaces. Yeah. The building itself, I'm happy to say that Abdul has always been very conscious of energy use. and sustainability. And this building could possibly be the first off-the-grid building in North Miami. I could be wrong. Maybe there is another one, but we're going to be very close to being totally sustainable. Why? We have solar panels on the roof. We haven't done a thorough analysis yet on how much we capture, but I'm hopeful that Abdul is actually going to be able to supply other people in the neighborhood with energy off of these panels. But at the very least, it will sustain the dry cleaning business down below. The other thing is that because we don't need air conditioning in a warehouse as such, we just need ventilation. What you see on the sides here, all of these are basically louvers. Okay, these are all louvers. These are louvers. The air will flow through the building. Okay. And in terms of image, I wanted to try to do something that isn't just like a box warehouse, which is what you would find in most industrial parks. They just say warehouse, right? We're trying to do more of an urban friendly building, even though it's housing a warehouse. Okay. Any questions?
No.
Okay.
Thank you.
Who has a
Do you have
question?
a question?
No? Nobody
No.
has questions?
No question.
You just want to
Thank you.
keep me here longer?
All right. With that being said, we'll open public hearing. If there's anyone who would like to speak on this item, now is your opportunity. Public hearing is closed. All right, board discussion?
I'm going to move, not just yet, but I'm going to move that we go ahead and recommend this based off of staff's recommendations.
Right.
But further, I mean, just to add, I love that not only is this an innovative business use in this project, but also it's an innovative, sustainable design and the type that honestly we need to see more of in this city. So, with that comment in mind, but also staff's approval, I'm going to move that we recommend approval on both items because I believe it's
No, you've got to do it
just
separately.
one at a time. Okay,
Separately.
understood.
Mhm.
So I guess we're SC-08-22.
-08-22.
Right.
Okay.
Mhm.
All right, so I'm going to move that we approve SC-08-22 under staff's recommendations.
I second that.
And did we get the
Great
four
project, Abdul.
criteria? Great. I'm
Great project.
just happy that that green structure in the back will be gone. Mr. Abdul, because today, I was there today, and trust me, I saw the gentleman taking the tank, and it seemed dangerous. But I'm happy about that. So it's been moved by Mr. Shields and seconded by Mr. McDermott. We'll have a roll call.
All right. Chairwoman Philippe,
Yes.
Board Member McDermott,
Yes.
Board Member Pierre Lewis,
Yes.
Board Member Shields,
Yes.
and Board Member Williams.
Yes.
Item
Now we
passed.
can deal with.
Okay. In the interest of time, I will also move that we approve SC-09-22 based off of staff's recommendations.
And I'll second again.
Okay. Moved and seconded. Roll call?
Board Chairwoman Philippe,
Yes.
Board Member McDermott,
Yes.
Board Member Pierre Lewis,
Yes.
Board Member Shields,
Yes.
and Board Member Williams.
Yes.
Item passed.
Wonderful.
Congratulations.
Thank you. Can't wait to see. All right, next one, V-12-22. I know I'm rushing, people want to get home. This is a fence height and opacity variance within front yard, and it's at 1035 Northeast 122nd Street.
Thank you, Madam Chair. As you know, this is Derek Cook, the Director of Planning, Zoning, and Community Development. As stated, this is a variance to Article 5, Division 12, Section 5-1210A1 and 3 of Chapter 29 of the City of North Miami Code of Ordinances, Land Development Regulations, LDRs, to allow, 1, a fence with the opaquity greater than 25% in the front yard setback, and 2, to allow a fence of 6 feet, it's exactly 5.5, but say 6 feet tall, located at 1035 Northeast 122nd Street, within the R2 Single Family Residential District. Said variance is to be reviewed under criteria set forth in Article 3, Division 6, Section 3-606 of the LDRs. So, we have had fences before us before, and we have had one most recently where they was deviating from the opaquity. So, you know, we have a criteria that they have a minimum, a maximum of 25% opaquity, which is what we call shielding, the lack of a better word, and they need to have 75% of visibility to allow for clear sight through the fence. The applicant has built this fence, it's existing, it's done without building permit, and here we are. They were cited. Here we are. And when it was cited, they come to us and we say, nope, you don't meet the opaquity and you exceed the height. Thus brings them to us today to requesting this variance to allow for these deviations from the code. So the property is approximately 10,350 square feet. It's in the R2 zone district. It's in a well-established single-family residence, a single family to the east, the west, the south, and the north of the property. You have pictures of the fence that that's in your packet. I mean, it's a nice fence. It just doesn't meet our criteria, but it's a nice fence. So as we know, as part of the review process as it relates with variances, we have 6 criteria that we have as part of our review. To allow for staff to give a positive recommendation, you need to meet 4 of the 6 criteria. As it relates to this property, they meet 3 of the 6 that we have. And those are as follows. Number 3, that the requested variance maintains the basic intent and purpose of the subject regulations, particularly as it affects the stability and appearance of the city. Yes, you know, it's intended for a fence to demark the boundaries of a property. The fence does that. And that is the intent. That's the language from the code, is that the intent and purpose of fence is to mark a boundary, provide security, and or provide decorative function. They're doing that. It meets the intent of the code. It just doesn't meet the height and the opaquity requirement. The other one is 5. The variance request is the minimum variance that will make possible the reasonable use of the land, structure, and building. We say yes in this capacity to legalize this fence. The fence is already there. They need the variance to maintain the fence. Without the variance, they would have to remove the fence. So there we are. So if you don't, it is what it is in that capacity. And the last one is 6. The granting of the variance will be in harmony with the general intent and purpose of these LDRs, and such variance will not be injurious to the area involved. The establishing of the fence would not be injurious. You can see the fence. It's a nice fence. It wouldn't be injurious to the area to have it there. It just doesn't meet the criteria that is specific to our LDRs, which is dealing with LDR section 5-1210 A1 and 2, of the LDRs, which has the requirement of the 25% opaquity being maximum and a maximum height of 5 feet in the front. It's also important to make this distinction. Our code also allows for people to deviate from that maximum height of 5 feet. When you do a decorative design, you can go up 6 to 12 more inches if you had a decorative design along the front, but it can't be spikes and things like that. It have to be something that is enhancing the design. They don't have that here, but just to give you an idea, if that was introduced, they would be in the characteristic of within the framework of the code if they were doing that. That's not the case here. Based on that, because the application doesn't meet 4 of the 6 criteria, only meet 3 of the 6 based on staff analysis, we make no recommendation. However, if the board deems it within their power to do so, within their will to do, to determine to the action to approve, consider the following conditions with this approval: that the applicant obtain a building permit and all necessary licenses prior to the site construction, reconstruction, reconfiguration of the works, and that the applicant install a periscope mirror at the vehicle opening of the fence to increase the pedestrian, cyclist, and vehicle visibility to oncoming traffic. That's my presentation.
Thank you, Mr. Cook. Is the applicant here?
Hi.
Good evening. State
Good
your
evening.
name and address.
Yes, it's 1035 Northeast 122nd Street.
And your name?
Daniela.
Daniela.
Good evening. My name is Daniela Frias, and as you all know, we're here because the fence in our property. I will restate the reasons why we put the fence in the first place, keeping my job in mind. I worked the midnight shift. I'm a police officer, and I usually have to take out in and out equipment at really strange hours, 3, 4, 5 in the morning. The reason why also 5 days ago at 1040 Northeast 122nd Street, which is in front of our house, it was vulgarized. The fence places a healthy limit in our boundary in between to maintain a harmonious environment for all. On the other hand, I would like the board to consider the fact that there are other fences in our neighborhood that are much taller than ours, and have zero visibility. Also, since I would like to mention that we have here pictures of other fences that are way taller than ours. I would pass it later at the end. Are way taller than ours and have zero visibility. And here are all the addresses. Also, I would like to mention that we have more than 25 signatures that are there of our neighbors stating that they do approve our fence, and some of them are stating that it even increases the value of our neighborhood. Please consider us keeping the fence. We've gone through a lot of trouble for this, and just because of a simple fence, we're just trying to keep us safe, and it looks nice. Thank you.
Thank you. Before I open public hearing, I just have a question. Did the company put in the fence for you, or did you guys do it yourself?
No, we did it with a company. So this is what happened.
Okay.
When we moved to the neighborhood, we contacted a company to do the fence. We assumed that they were doing it the right way. Unfortunately, one day I'm getting out of the house and we see the red paper saying that we don't have the permit, and now we're here. So we're just trying to do it the right way now. But unfortunately, we thought that it was being done the correct way.
All right, thank you. Mr. Cook?
My apologies, Madam Chair. If I may, I want to add one more condition that is important related to this situation. that all portions of the existing fence within the city's right-of-way be removed and reconstructed along the property line. It is some concerns that, and this is, salient to what the applicant just spoke of, that they had a contractor, that person came out, did the work, but they did it without building permit, and it looks that it was placed outside of the property line into the right-of-way. That's not permitted. That's not something that we can vary here. It would need to be adjusted to at least be on the property line or within the property.
Derek, if I may ask just a sidebar question, probably to be discussed at further length. You know, I was reading in the paper in the Sun Sentinel that some of the cities are now putting heavy fines on contractors who just come in and put up structures and fences and that kind of thing. And, are we doing that? Because I see it all over the place, and we hear about it, all the time. Do we have a mechanism when some contractor comes in and this poor lady's just trying to get a little safety, and they just, and she's the one who gets, she's the one who winds up getting the code enforcement fine, when it's really the contractor that needs to be leaned on very heavily. This is not a free-for-all in North Miami, hopefully. So are we doing that? And I say maybe this is just a future conversation, but are we doing anything of that sort?
None I'm aware of. I need to speak with the building director to see if they have any kind of policy like that, because you're falling into that realm of, the contractors that you understand, Mr. McDermott, they're operating through the building department to do this, and if it comes up that it was a property that was a structure done without permit, is there a penalty that said, oh, we're going to reach out to that contractor and say, hey, you didn't do this, you have a fine that you need to. I'm not aware of that being institutionalized.
That was just a question.
What we have really is more so on the resident, because what they have to do is they got a additional fee for after the fact permit.
Well, in some ways, we have to do more in terms of the education of the public, because they have to know, even if you get a company, if you don't see that paper on your door stating you have the right to do the work, then you don't have the right to do the work, okay? And I'm pretty sure that she probably paid a fee for permit, which was never, taken out, so. They do it all the time.
Yeah, unfortunately. I do agree with your idea, Mr. McDermott, for sure. Quick question to Mr. Cook. The applicant showed us some analysis about other fences that obviously break the unfortunate rules in our code on opacity and height. Did you or your staff find analysis that back up those claims within this particular neighborhood?
No, as you're aware, Mr. Shields, when we have had other applications come up of this exact nature, that people have brought to our attention the deviations that exist within the city, which are prevalent out there. So we didn't do the analysis, but I accept what the applicant said, that it is very likely that she had that existing within her neighborhood.
Okay, well,
Okay.
I'll open public hearing, since I didn't do that. Let's try to stick with it. Anyone for or against this item, this is your opportunity to speak.
My name is Mary Schuweiler Hoover. I live at 1070
can
Northeast
you speak into the
122 Street.
microphone?
Is the microphone on? Or no?
Yeah,
It-
now we
it-
can hear
it's
you.
on. We can
Thank
hear you
you.
now.
Again, I live at 1070 Northeast 122 Street, just several houses up from the applicants. I do take issue with the assertion that there are other fences. I've lived in this neighborhood and down this block for 22 years now, and there isn't a single other front fence in the front yard on any house on our street. There may be fences in the backyard that face the alley or the very narrow drive that is functionally an alley, and yes, those fences are opaque, but none in the front yard of any home on this street. I also take objection to the assertion that what was it? Yes, I used to run at 4:30 in the morning, and I'm not a police officer, but I didn't find the neighborhood to be in any way, shape, or form unsafe. I would note that this driveway, this fence requires one to exit their car, get out, open and drag the gate open, then bring their car in and get out and drag the gate closed. So as an issue of additional safety, it's hardly, it does expose one, I would think, to more risk in having to do that than simply drive into their driveway, get out of the car, and walk into their home. Regarding signatures, no one approached me. I would have been happy to give them my opinion on this fence. I'd like to give you a little bit of background about how this fence came to be. This was a lovely home, beautifully renovated on the exterior by its previous owners and sold to the family here. And that included a driveway expansion, beautiful landscaping in the front, a very open and elegant front facing, in keeping with the improvements made to our street by numerous homeowners, myself and our neighbors included. These folks then came in, and before long, on a weekend, mind you, a fencing company showed up and started to install this fence and whipped it up in a day or two. Many neighbors, myself included, went up and said, "Hey, you guys are really close to the street. Hey, you might want to call the homeowners. Did you guys get permits? Oh, yes, we did. Are the homeowners aware of what you're doing? Oh, yes, they are. Mind your own business," we were told. We tried to raise our concerns as the fence was being installed on a weekend, with the knowledge of the homeowners. Their concerns, and I have pictures here, are that the fence is tall, it is dense. I don't particularly find it to be attractive. I think it is unfriendly. I think it is unwelcoming. It is not in keeping with the open and beautifully landscaped feel of most homes on this block. In fact, it is the opposite, and it is crammed with cars. They have 6 or 8, and many times need to park on the street, which they cannot even do. I have photos showing that when they do so, because of where the fence lies, they're half on the street. In order to open their fence, they have to get out of their car. They block the street in doing so. It is hardly neighborly. It is hardly friendly. I have never met them. They have never talked to me. They have never made an effort to get to know the majority of folks on our street. Sure, thank you. And I find all of these things to be not in keeping with what the family is putting forward or the speaker is putting forward to you this evening. I find it to be somewhat disingenuous. Again, I find it to be imposing, unfriendly, and in my opinion, unattractive. What it said to me the first time I saw it, I thought, my goodness, boy, that's a fence. It made me think of houses with bars on the windows. It made me feel that this was a neighborhood that screamed, we have a concern about crime. We're in a crime zone. I didn't buy my home
Sorry,
in
your
this area.
2 minutes have expired.
My home in this area to live in a neighborhood where that's the vibe. And I find this to be offensive, and as a homeowner, I find it objectionable.
Thank you. Anyone else?
Good evening. I'm Dr. Santos Lima. I live just in front of the property on 1030 122nd Street. Well, exactly when they arrived, and when the fence was built, then there was Mr. Orozco that is on 1045 that came to discuss with the contractors. I also came and asked, listen, do you have a permit? And they said, yes, we do have, right? Madam and Mr. Friars were traveling, right? And then they said that they were aware of the construction. When Mr. Friars were back, then I said, listen, you, because you're giving to a contractor, you have still responsibility on what we're doing. Well, I have trunks in front of my property with bromeliads. Then the cars have been touching my bromeliads and destroying my plants. They kindly rebuilt I have a border on wood. They kindly rebuilt. I also, every time I have all those cars parking in the street, we have half of the cars in the middle of the street. I agree, it is unfriendly. There is no other fences on our street. We are a great team. We help each other. We take care of each one. I help people doing their gardening. They help doing the hours. There is people that blow the street. This is unfriendly. When Miss Frias leaves the car, she arrives late, and then she needs to get out of the car, open the door, open the gate, then this is not protecting at all her. And Mr. Frias said to me that she needs to protect all the guns that she leaves on her car. because she leaves by night the guns that once she's a woman. I don't think this is very protective to our neighborhood to have guns in the cars during the night, and it's not the reason to construct a fence around the house. I really think that's so unfriendly. I have friends that came from Brazil and Brazilian to visit me, and they said, why they put such a horrible fence in front of your house? It's in front of my house. I need to live with this looking every day. My apologies, Mr. and Ms. Frias. I respect you. I think you have a very beautiful family. But this is horrible. This is a mastodon that just arrived to our beautiful street. And I told Mr. Frias, when you bought your house here, it's because there is an harmony on our street. Why you bought this house here then? Why you building this? It's like a prison. I feel prisoner.
Please note the
Okay,
time.
thank you for your attention. And I oppose the construction of and there is the setbacks. Please.
Thank you. Okay.
Good evening. Valerie Holt, 1050 Northeast 122nd Street, resident 51 years. A couple of things I want to address. First is, so far as protection, I'm 75. I could climb that fence in 30 seconds, no problem. So it doesn't protect keeping somebody out. As my other two neighbors said, you have to actually expose yourself in the street. So it's not for anybody's safety. But that's not the issue. It's why is this kind of behavior being rewarded by giving a variance to the height? I mean, it's massive as it is, to add more. They were notified. People try to stop it from going. They're in the middle of the swale. They're 9 feet away from where they should be. They're only 5.5, 6 feet from the road. 15 feet is where the setback is. They're directly over the sewer lines. They put this fence. The last thing I want to address is the fact that you were told there's fences throughout the neighborhood. There isn't. The end of our street dead ends, and then you either go north or south. You know, you head east, and it goes north or south. It's not a through street. All along that is the back of those other people's property. We've called it the alleyway, but it's lived here forever. It's 11th Avenue. There's a different setback for those houses because it's their backyard. Your backyard, you're allowed to put a solid fence. You're allowed to have 6 foot. That's what those people have. Those are the only other fences around. There's nobody on our street or even the streets over or in either direction that have fences, front yard fences like this. I know the issue isn't to whether they have a fence or don't have a fence or a limit. They are entitled to have a fence, but they're not entitled after their behavior to get rewarded by having an additional foot on to their fence and to have more opacity. They're going to have to tear up the front of the fence anyway, because by law they cannot have it in the middle of the swale, which is they've done. And like I said, our neighbors went up. When they moved in, the day they moved in, I walked up the street and welcomed them to the neighborhood. You know, and I'm still welcoming them to the neighborhood. But this has caused a lot of dissension. I also was not approached.
Please
I
note
mean,
the
I've
time.
talked to them.
Thank you.
I was not approached. I don't know the names or the addresses on
Thank
the
you.
25
Thank you.
petition. Thank you.
Anyone else?
Good evening. I'm Alda Proserpina, living in 1025 Northeast 122 Street. In fairness to Mrs. Gonzalez, I met twice because they don't speak English. They always speak Spanish. So when I met Mrs. Gonzalez, because there is something hanging in their yard, our moringa tree, and they approached me if they can cut it. So, okay, Mrs. Gonzalez, I will cut it. But they request they will cut it by themselves because her husband has a saw and she's now busy. I can cut, my husband can cut it. So, okay, Mrs. Gonzalez, just put all the branches in our yard so we can pick it up to put in the front. No, it's okay. Then 1 week after when I came back, it's already clean. The moringa is cut and very nice. That the cutters of branches are no longer there. Then he mentioned to me the reason why they build the 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 fence because of their safety, their protection. Because when they first time move in, there is a car parked in front of their house and watching their house. That's why they are very fear to leave. That's why they put the fence. In fairness of Mrs., they are very good person. Thank you.
Thank you. Anyone else?
My name is Roberto Rosco, 1045 Northeast 122nd Street, North Miami, Florida 33161. I'm the neighbor to the east of the said property. I don't know if, having had contact with Mr. Shields in a couple of occasions on a social setting prevents me from or giving a pro or against opinion. But I just want to bring back
It does
some.
not.
I'm sorry?
It doesn't.
No conflict.
No conflict. Okay. I just want to appeal to try to bring back the peacefulness that we used to have in the neighborhood. I am also somehow related for 22 years to law enforcement, as I am a head of compliance of a banking institution. And before forging an opinion, I went to the city for the first time on a matter like this on Monday to ask for the facts, the ordinance, and the details of this whole controversy, the city, the neighbors, the petitioner, and whatnot. One thing I want to recognize, and speaking to Mr. Cameron, is the fact that the neighbors have all the right to do a front fence, whether we like it or not. Okay, and I think that's established by the ordinance. And I don't want to lay out and repeat the different aspects of what will be allowed to be built in front of a house as far as height, transparency or opacity, and the boundaries of the fence itself, which I think are very well delineated within the information that the city has put forth. The only thing that I will ask, because I'm not going to repeat, and the facts are out there, I think you have enough elements to decide whether to provide the variance or not.
Please note
Is
the
that
time.
is there any and I go as a compliance officer, is there any precedent to a variance of this nature in the entire city of North Miami? That's the only thing that I will go for, to be fair and be on the compliance side.
Thank you. Anyone else before I close? The applicant like to say something else? Go ahead.
So I just wanted to answer a few things. First, the day that I went to work that night when my car went above his grass. The next day in the morning, it was really late. That day I worked out of duty. I worked my shift in the morning. I worked out of duty. I know it's not an excuse. I was tired. When I was backing in, I hit his grass. The next day in the morning, first thing in the morning, which he did not mention, I knocked on his door. Morning, I was the one that hit your grass. It was me. If it wasn't because I knocked on the door, he would have never known. What did my mom do? We went and we fixed it. That wasn't mentioned, but that's all right. Next. Only 3 people.
No, we can't have that.
Also, I knocked on the door.
Okay, guys, you had your chance to speak. She has
There's-
every right.
There's no cross
is the
rebuttal. This is
applicant.
rebuttal. This is allowed. Please maintain decorum.
Again, as you have seen, there is a list of other people that have approved our fence. We have them that they don't like. It's more people that approved it than them. Again, as I mentioned, that day I worked on late shift, and I owned the fact that I did that, and I knocked on his door, and we fixed it. My dad fixed the wood that was there. He mentioned, which I guess he didn't understand me correctly, I said I put I have the guns in the car, and I put them inside my house. I never said I leave the guns inside my vehicle. That is not allowed. I would never leave my weapons inside of my vehicle.
We cannot have you speaking from the audience. I'm sorry.
I never said that. He mentioned
on,
that.
ma'am.
I'm
Hold
sorry.
on. That's why we have public hearing. We gave everyone the opportunity to speak for 2 minutes. As the applicant, she has the right for rebuttal, and then we end it. We will have discussion among ourselves, and a decision will be made. Okay?
Please do not call out.
You cannot say anything else. We don't want to have to call our officers that's out there to ask you to leave. I don't like to see that. Continue.
Yeah, the last thing I wanted to say again, I never leave my weapons inside my house. I didn't inside my car. I never said that. I bring the weapons inside of my house, but I do have to take them out while I'm in the parking lot. So I just wanted to mention that.
All
Thank
right.
you very much.
Thank you. All right, public hearing is closed. May we go on with board discussion?
Well, you know, this is a specific style of fence. And if all of you remember pre-pandemic, we had a case with this style of fence.
Mm-hmm.
And I made the comment at the time when we did give the variance for opening Pandora's box.
We can't hear you in
Ms.
the mic.
McDermott, I'm not sure if they can hear you.
Oh.
Is it on?
Oh.
It is on, yes.
You may
It
want
is
to just
on.
speak a bit louder.
Can you hear me, Gary? No, it's me. What I'm saying is, this is a specific style of fence, and pre-pandemic, we had a case that went on for 2 hearings on this particular fence, particularly with the opacity on it. And at the time, I mentioned that we were opening Pandora's box, approving this style of fence. You know, the police department and the fire department have both issued directives of how they can see into a piece of property. And I think we need to abide by that, just to accommodate somebody who has a fence thing, they for some reason feel they need to have a fence. That's fine. I don't know where that comes from, but you know, I still think that, you know, height and opacity are important items, because they are the code of the city. And I think if we continue to just give variances constantly on this kind of thing, you know, it's like, why even have the ordinance, you know? I mean, there comes a point where we're seeing these all the time now.
Right. If I can.
Oh, I'm sorry.
Go ahead.
No, I was going to say, I hear what Mr. McDermott is saying, and I was one who said that these fences will be coming to us because it is the style that's going on. It's more like the stable type of thing. And when I look at the pictures, to me, you can see. I don't have a problem with the opacity of it when you look at it, but I do have a problem with how close it is to or off their property line and close to the city's swale and all. If you look at this picture, it's sitting right against that light pole that's there. So if they're gonna make changes, that's my suggestion. If they're gonna make changes anyway, because they have to conform to that, then they can deal with the 5 foot that is required in the front, and you know, and take care of all the issues that presents with their fence. I think you can see through there. My problem with opacity, Mike, is if you've got a fence that's like a solid, you know, that there's no way. because one, you can't see what's going on there, okay, but this, I think, as I said last time, it's coming and it's enough.
Particularly
I just
at night.
add?
And
Okay.
these are rules that were established by the Miami-Dade Fire Department,
Mm-hmm.
okay, and by the police department.
Mm-hmm.
And they felt that these lattices, particularly all times considering 24 hours a day, that they were too close to allow them to have the view that they needed. Now, they wouldn't have just arbitrarily said, oh, gee whiz, let's, you know, when you have Miami-Dade Fire and when you have the police department saying, this is the view that we need, because we'll be looking through that fence 24 hours a day, possibly. This is what we need, that we should, I don't think we should just continue to override the fire department and police department and say, no, we want to do this, because some fence company, you know, has a particular style that they're not willing to modify. You know, I just,
So I just want to add one. I don't take issue with the style. I think, you know, when we talked about this pre-pandemic, the opacity is really determined by the spacing, right? And so that is a very, very easy fix. And so I agree with you in the sense that, like, I believe the style is beautiful. The fence is gorgeous. But I think it is a very easy fix in terms of the spacing that people are putting in. And so I agree with you in that we have to, we really should be following what the rules say. But I think I want to add that as a board, we oftentimes have people who come and present, and we are making, you know, exceptions because, you know, they do something in advance and they don't get the approval that they need, and we're oftentimes approving something afterwards, right? And it just so happens that in this instance, we have a lot of people in the audience who said, well, they knew, right? We went and we knocked on their door and they knew, but they chose to install that fence even without a permit. And so I will say that I really do take that into consideration, because oftentimes we don't have other people from the community saying, hey, they knew. And this is an instance when we do. And I think as a board, when we make decisions, you know, we oftentimes are lenient, right? We try to give people the benefit of the doubt. We make the assumption that they don't know. But I think in this instance, you clearly have a few residents who say, well, we made sure they know. We told them. And so I want to add that for discussion, because I think we oftentimes get a lot of these variance requests coming to us, and we don't have people in the community coming and saying what was known before the installation actually happened.
well, and the chairwoman made a very good suggestion. Since they're going to have to replace this fence anyway in the front, because they built on the city easement, okay, why not ask them to just build it correctly?
Right. So, I mean, if I can jump in with a few comments here.
I'm sorry, go ahead.
No worries, no worries. I want to be deferential to our board here. So, I remember that pre-pandemic case intimately well. It took us, I believe, 3 Board of Adjustment meetings, not 2. And I think it was 6 months and a considerable amount of staff analysis, review that was involved, et cetera. And to the point that was just brought up, you know, I agree with you, Mr. McDermott. We don't want to set precedents per se. But I also, to the other points that were brought up, these are on a case-by-case basis. And in that situation, there were a couple of things within that precedent that we made that I think are important noting. One, they came to us prior to the fence being built. That's first. Second, we had considerable analysis based off of issues of safety, which they similarly brought up, as you all remember, and we had analysis that went into our decision on safety. 3, that particular street was one that had a considerable amount of traffic. And after the second time they came to our board, I actually went out to the property myself, because I'm like, it's been like 4 or 5 months, what's going on? And I actually saw it myself on a Saturday, how busy it was, let alone I could only imagine during the week, and that compounded on the safety issues, right? And further, my understanding was the opacity issue was not only a city issue, but also a state legislative piece, and that the opacity that they were suggesting in the case of that fence, I think, was only like a less than 10% variance from what our city actually presupposes. Like, I think the rule is 25% opacity, and I think they were suggesting like 27.
It was, my issue was that it was greater than that.
Right. Well,
Or
listen,
less
but
than
beyond all of that, we approved it, I think, because of a lot of considerable thought and very specific issues to that case. I don't think it was a precedent we set, but I think it's important to know that there was a lot of really specific incidents that went into that case that we spent a lot of time thinking about, which is why we voted on it, but I don't think we set a precedent per se to just roll over this issue in the future. That said,
And it didn't have the issues of.
no,
being on the-
it didn't. And I'll say in this case, I absolutely hear the applicant's situation. I feel for them in a similar situation of, hey, safety is a concern. And I definitely hear you, like, I mean, anybody here can look up my address. I live on 2041 Northeast 135th Street. And I think my street's pretty safe. However, we've recently, like, in my condo complex had issues, like, literally next door, a police situation. And I definitely can understand where you're coming from on that. My other concern, though, is that this fence was built without, like, without any type of permit, without any type of variance provided by this board prior to its construction. And further, not only was built without that variance, but was built over a city easement, which creates can create a huge public safety issue, not only in it being built over the sewer line, but also in potentially parking and the other items that were mentioned by folks. So I mentioned all that to say, in a similar way, 2 years ago, we had to make a lot of analysis and considerable thought on a similar case. We have to make that same amount of analysis and thought. And that's why I asked Mr. Cook 23 minutes ago if there was analysis of similar fences that had 0% opacity, or excuse me, 0% visibility in the neighborhood, which was mentioned by the applicant, because I wanted to make sure that that was a part of your analysis. And you said, no, we didn't have a chance. We didn't necessarily see it in our analysis. And I know based off of the Google Earth analysis you made on previous things that you all are quite thorough. So I get it. All that said, here's my recommendation. I mean, my thought based off all this. My thought is that I think a fence is important, and it's certainly within your legal right to build one based off of zoning and what's appropriate. My suggestion, just based off of this circumstance and how this fence was built and the issues surrounding it over the easement, safety, etc., my suggestion is that we actually go with staff's recommendation here, and that hopefully we bring in, a proper fence that not only matches our code, but if needed, has the proper variance pre-approved by this board prior to its construction. And I think my opinion there is that I think would make all sides here hopefully provide a solution to not only neighbors but also residents, the applicants here. Just to re-clarify what I just said, I'm supporting staff's recommendation here of voting down on this particular issue of the fence and not approving the fence, just to be clear. Just to be very, very clear. And that is staff's recommendation, correct?
Mr. Shields, we actually gave no recommendation.
Oh, no recommendation.
No
Okay.
3-3.
Okay.
3-6.
3-6. Understood. Well, I'm clarifying what I think the recommendation should be. And board, tell me if you disagree with.
Is that a motion?
Let me.
Yeah, let's. I want to clarify it to a motion for
Yeah.
sure. This is
Before
important.
you clarify, because what I said at the beginning
Mhm.
was there's going to have to be some modification to this fence no matter what.
Absolutely.
That applicant has no choice
Mhm.
because it's on city property
Mhm.
and we need to get it off.
Mhm.
So she will have to contact her fence company to come back and move this fence to the proper
Setback.
okay? As she does that, she certainly can modify the front part of her fence to meet, which is the 5 feet
Mhm.
instead of the 6 feet. Because I do think they're allowed, what, on the side, Mr. Cook?
Well, through the chairperson, what you allow in the first 25 feet and along the front has to be 5 feet, and it has to have a minimum of 75% visibility, transparency. Beyond that 25-foot area, they can be totally opaque, and it can be 6 feet tall.
Okay. So what I'm envisioning, and when they come and they have to modify it, because after spending all this, I'm pretty sure they don't want to take the whole thing down. So they might need to do the front up to 5 and the side up to the point where it can be 6. So you're just gonna have a fence that looks like this, goes like this, and then go up. Because it's a lot more economical for them to do that modification than to take down the entire fence.
Can I ask a quick question, Mr. Cook? What's the current opacity on this again?
I think they actually have more space than the last one that we voted on, because you can clearly see the house and everything that's in
But it's a
there.
very similar design to
It is.
Mr.
Yeah.
McDermott's
It
point.
It's the exact
No,
same
It-
design.
It's, the design is the same, but the
Similar.
spaces, the spaces between the slats, is much more open than they had.
Since they're gonna have to redo the fence, they can redo the opacity as well.
And I want to clarify, so what we're approving all has to do with the front fence anyways.
Yes.
And so,
Yes.
to that point, then it would just make sense to not approve this, right? And they have to go back and get the correct permits, because nothing that we're dealing with, I don't believe, really has to do with the sides. It's the front anyways.
Yeah.
So for us, we might as well just,
Well, the sides up to a certain point, because if it's coming all the way up to meet the front,
Fair enough.
then all that section has to be 5 feet until it gets to that part of the home where it can be 6 feet.
correct.
So,
Okay, so.
I'm sorry, Mr. Cook, you
No,
had
no,
something?
Thank you. Through the chair, to Mr. Shield. So it had been advised to staff that their separation is 2 inches between the slats. And as further clarification, their front yard is the front yard setback area. So that 25 feet is their entire front yard. So when they have to do a fence, it's gonna have to be modified, the whole fence, to meet the requirements. Yes. So to be clear, in the R2 district, you have a setback of 25 feet from the front property line.
Mhm.
That 25 feet area is their front yard. That's all they have is
Okay,
25
so they
feet.
can't close. They can't.
So I'd be happy to make a motion.
Please do.
I'd like to make a motion that we deny V1222.
Okay. Okay, it's been moved for denial by Ms. William and seconded by Mr. McDermott. Okay. Any other discussion? Board discussion? Roll call, please.
Chairwoman Philippe,
Yes.
Board Member McDermott,
Yes.
Board Member Pierre-Louis,
Yes.
Board Member Shields,
Yes.
Board Member Williams.
Yes.
Item has been denied.
So, for clarification, they have denied your request. So you would still need to go through the building permitting process because you've been cited. And the only way that you can modify this at this stage, except you choose to appeal it to the zoning appeals board, which is city council, this decision, is to, A, put your fence at your property line, and it would need to meet the minimum requirements of 25% opaquity, and it would need to be no taller than 6 feet. And as was identified by staff, it seems that your whole front yard is the 25 feet area, so that means that entire fence that is located in front of your house needs to be modified to meet the code. And you need to go through the building permitted process to do so.
Okay.
Yeah, never mind.
All right.
I think he has to take that up.
I'm sorry. Did I miss something?
It's 2 inches they have between, so normally to meet the opacity, capacity, you need 4 inches.
The sides are 4, because when I actually.
Okay, so the front,
It's just the front.
just so it's the
Sides are
front.
correct.
So they
I'm
just
just
really
gonna
need to
mention, I
modify
hope
that
that
side and
you go
reduce
through
the side.
building, I hope you go through the proper permits, come back with a fence that, meets code.
Right.
Yeah.
It's not like we don't want you to have it, we just want to make sure it's done up to code.
All right.
Immediately, they've been cited.
Because actually they built it in March, so it's.
Next case is V-13-22, a variance to the required setback for a trellis. 12615 Cypress Road.
And with the next
Oh,
case?
my God.
It's
I'm sorry?
There are two
Oh,
requests.
I'm sorry. V-1422, also the same applicant, a variance to the maximum floor area for a trellis. 12615 Cypress Road. Okay,
Thank you.
thank you.
Thank you, Madam Chair. So the last 2 items on the agenda for the evening, we have before us a variance request for the property generally located at 1035 Northeast 122nd Street, a variance to Article 5, Division 12, Section, excuse me, I'm on the wrong one, but we'll move forward. We'll move forward.
It's a long night.
So we have a variance for a trellis located at 12615 Cypress Road. And is a variance to Article 5, Division 1, Section 5-103 of Chapter 29 of the City of North Miami's Code of Ordinances, Land Development Regulations, LDRs, 2, 1, to allow a trellis to encroach more than 75% into the required yard setback, and 2, to reduce the required setback from 5 feet to 4 feet to any property line on the property located at 12615 Cypress Road in the R1 district. Said variance is to be reviewed under the criteria set forth in Article 3, Division 6, Section 3-606 of the LDRs. You also have, at the same address, is a variance to Article 5, Section 1, Division 1, Section 5-103 of Chapter 29 of the City of North Miami's Code of Ordinances, Land Development Regulations, LDRs, to allow an increase in the maximum permitted area of the trailers from 400 feet to 468 feet at the properties located at 12615 Cypress Road in the R1 district. Said variance is to be reviewed under criteria set forth in Article 3, Division 6, Section 3-606 of the LDRs. So, get to that. As stated there, you have the issue with the trellis, which is a new trellis. The applicant had an old trellis at the location that was also non-conforming, and with size and setbacks and things to the effect. Some criterias have, with this new trellis that they have put up, because of the old one, it was in disrepair. They were not able to modify it, to improve it. They had to just to get rid of it and then put up a new one. In that, they did increase the setback, which used to be 3.5 feet, now it's 4 feet. I think the size is kind of increased on it a little bit.
It was reduced. We don't know the square footage of the old one, but.
Okay, so we're not sure, but, so that's what we're looking at. So it's a slight, less conforming situation than it was originally, at least as it relates to the setback. So maybe you can put a slight feather in their cap for that, on that aspect. As stated in it, as you notice the section, what it's dealing with, you're dealing with the setback requirements, 75. You're dealing with the side setbacks at 5 feet, and you're dealing with the size being more than 400 on the first one. And you're also dealing with, forgive me, I have become a little tired at the end of the evening. My apologies on that. And you're also dealing with, as I said, the size of the item. So, as you know, we have 6 criteria that we look at when we're dealing with our variances. You'll need 4 of the 6 to be able to get a positive recommendation from staff. In this instance, staff was able to give 2 of 6 for the first item. And the 2, as it is, are number 3, that the requested variance maintains the basic intent and purpose of the subject regulations, particular to the effects and stability and appearance of the city. Yes, the property is zoned R1 with a future land use development, land use designation of low-density residential. The proposed variance will permit the trellis as an accessory in the rear of the property, 4 feet setback from the property line. The amount of reduction is 1 foot from the LDRs. The LDRs require 5, they're seeking 4 on the thing. The proposed trellis does not deviate from the allowed single-family use of the property and does not increase the property's density above what is anticipated for the LDRs in the R1 district. As such, the requested variance would not be negatively effective in the stability and the appearance of the neighborhood. And 6, that granting the variance will be in harmony with the general intent and purpose of these LDRs, and such variance will not be injurious to the area involved. So granting the variance, as we say, you only have that 1 foot deviation from the minimum required of 5 feet for the property. So let's take it into context as I somewhat spoke of. They originally had a trellis there that did not meet our requirement, which is the minimum 5 foot setback and the maximum floor area of 400 feet. It was larger than that. To what extent, we don't know specifically what it was, but it was larger than that based on the pictures that they had. If I recall correctly, I think it was 18 by something, if I looked at the pictures, when I looked at pictures. So it was a little bigger than that, and it didn't meet that criteria. Now, at least with the new one, you're bringing in a stable trellis. You're bringing in something that is going to be at least nice for the neighborhood. It wouldn't be something that the neighbors would not say, oh, this is unusual, because there was already one there before, and they have at least increased the setback slightly from what it was originally. So in that, we say that in the general intent, that it still is harmonious and that it would not be injurious to the area, because, you know, we allow for trellises and things to that effect, and there was one already there before that did not meet the standards of the code. So with that said, staff says that you only have 2 out of the 6 that are required. So with that, we don't give any recommendation for this item. However, if the board deems it within their will to grant this approval, the following conditions are recommended for consideration: that the applicant obtain a building permit and all necessary licenses prior to any site construction, reconfiguration work at the site. So the other item, as we talked about, you talk about the size of it. I've gone into that to a certain extent already with dealing with the setback requirements and other elements that they are seeking of. And in this aspect, with the review, I believe we also only found 2 of the 6 requirements, the same two that was before you, before the 6 and 3 being yes on this item, and it's the same as before. They don't meet the threshold for staff to say, give them a positive recommendation. We leave it in your hands with no recommendation on this item. And if you do deem it within your wisdom to give them this variance, that we request that you have this condition, as it was for the first one, that the applicant obtain a building permit and all necessary licenses prior to any site construction or reconfiguration work. Thank you.
Thank you. Applicant?
Good evening to all members of the board. My name is Martin Littman, 18955 Northeast 21st Avenue, North Miami Beach, Florida, 33179. Thank you to Mr. Cook. I think all of his appreciations are, we agree. We want to point out that we have submitted for a building permit already, part of, in the set of plans that,
I'm sorry.
I'm sorry.
You're not the applicant, but you, the architect, you're the applicant. Okay.
Yes, Mr. Mizrahi is here, the owner, yes. I believe he signed also for me to represent and speak on his behalf as well. No, what I was just wanted to start with clarifying the fact that we've already submitted a set of plans for a building permit, which part of those plans are in this package for the variance. There's a page, as you can see, where all the structural design and calculations have already been done for the structure. As Mr. Cook was pointing out, the condition of the previous pergola gazebo was unrepairable, and yeah, it is. I believe, I think it's fair to say it is slightly smaller because of the fact that it's the same width, which is the 18 feet, but it is shorter. So I believe technically, I guess it is safe to say, when you asked me before I was thinking about it, it is slightly smaller. I understand that it is, the difference is minor, but as we were pointing out, the fact that it's 1 foot less encroachment is also, I guess, smaller in size. Just some quick things. I know it's late. It is safe to say that it is a very lightweight structure. It's an aluminum structure. It's a pergola trellis type roof. So it's not like this is a heavy structure that's imposing into the rear yard or anything of that nature. I think that's very important to point out. The columns are literally 4 by 4 inches. Or I think 6 by 6, I'm so sorry. Another very important item, I think, is this is not close to any of the side property lines. This particular structure is in the center. It has 130 linear feet on the water. So this is about 80 feet from what would be the south property line to the neighbor to the south, and 40 feet to the neighbor to the north. So this really does not generate any issue architecturally impeding any type of view, or it's not close to the property line so someone would, his neighbors to the north or to the south would see it from their homes or from their properties. I guess it is also important to point out that Mr. Mizrahi recently renovated the entire property, and in an effort to make this a safer structure, the foundation was already built, it was permitted, it was inspected, and it was approved, which was various gray beams and concrete structure below that is existing, and like I said, it was already approved, so we are attaching to that, and it would be extremely safe as opposed to what was there before. I think that, well, I don't think, it is confirmed because Mr. Mizrahi greeted him at his home. The building official was there to confirm that the structure is a safe structure, or the design is according to the structural code. And finally, we have 2 letters here. They were sent to the city. It's not a signed petition or people just basically signing a paper. These are specifically written letters from the neighbor to the north and the neighbor to the south, where they speak about their relationship to the property owner and how this structure would be deemed approved by them, and it would generate 0 problems on their behalf. I don't know if all of you had a chance to see these letters, because they were recently signed. I have copies here.
We have,
They're pretty long, and
We
I
have-
would love to read them because actually one of them is amazing, but I think you have them, okay. Yeah, I think, I don't know if you would like me to mention anything else. Yeah, I mean, so just to yeah, no, I'll just close with one thing before I give you the microphone. It would be a safe structure now. I think it's beautiful. It goes well in regards to how architecturally it blends with the remodel that Mr. Mizrahi did, and the neighbors who would be affected, north and south, took their time to write a beautiful letter, and I think this really isn't generating any issues for anyone in the neighborhood. It's in the rear, and I'll leave the microphone to Mr. Mizrahi.
Good night, everybody. Thank you for your time. I know it's very late. I'm just gonna say that nobody said that we bought the property in 2018, and the previous structure was from 1960, which was super unsafe, and we didn't even thought about keeping it just because we had the right to keep it. You know, we tried to honestly do something that was I'm sorry for my English, architectonically consistent with the design of the house, and something that would be safe in case of a hurricane or any other nature phenomena. That's it. Thank you.
all right, thank you. Thank you. Public hearing open? Public hearing closed. Board discussion?
Well,
No?
I just,
No
you know.
questions?
Well, I just, I'm in favor of approving the ordinance. We have 2 items in the analysis. I think perhaps,
Well, in terms of the criteria, they've identified 2,
they've identified 2.
but I don't know, I think number 2
Well, let's see.
is something.
Madam
I
Chair.
think-
I'm sorry.
So the typical justification for the granting of a variance is an odd-shaped lot. And in this
It
case,
is.
Are what? I'm sorry.
odd-shaped
odd-shaped
lot.
But
And this
isn't,
is clearly an odd-shaped lot for
Yeah.
which there is very little room
exactly,
to provide any kind of additional structure, and to the extent you acknowledge that some protection from the elements is appropriate, given this is South Florida, the motivation to put some kind of structure out there is obvious. So I would
We also have
least
the variance
suggest
request is the
that
minimum
item number
variance that will make
2,
possible reasonable use of the land structure.
the odd-shaped lot is the unusual circumstance.
Right. And what
you-
about number
you-
5? The variance request is the minimum variance that will make possible.
I guess it's number 1, that it's
Number 1 is better?
circumstance exists which is peculiar to
I-
the land.
I can
Okay.
agree with Mr. Held's interpretation of number 1 being yes,
Yeah,
based
the
off the
odd
odd-shaped
shape.
lot.
Mhm.
And I want to push on number 5 to your point, Mike. Just want to figure out how exactly we phrase that. Let's see.
Could we also,
Yeah.
so what, forgive me, board, my apologies, Madam Chair, if I may.
yes, you may.
To Mr. Hill's suggestion on the odd-shaped lot, which he's totally correct. Odd-shaped lot is grounds for a variance. Generally, within the setbacks, he was looking at it for number 2. I think within the could it be for number 2 and number 1?
Well,
Yeah, I think number 2, because everyone is entitled, or they're able to have that gazebo or something similar.
Right.
But the fact that where their property is located and how they need to fit
No.
it.
No.
You know what I'm saying?
Mhm.
yeah. That to me is number one.
Yes,
Okay.
number one,
So
for
we
sure.
can use number one and number two?
Number two is dealing with the neighborhood as a whole,
What about five? That's not the maximum variance that they've been asking for, but it's one that will make possible the reason the use of the land. Yes? What do you think?
Could we say number 2, given that,
Makes sense.
you know, it's
Well,
in
I-
Keystone Point, a neighborhood in which
You have a lot of odd-shaped lots.
there's a lot of odd-shaped
Yeah.
odd-shaped lots in which this type of variance request, I'm sure, has been done before and is not necessarily unique to this particular property.
Yeah?
Okay, all right, that's it.
You're the deciders.
Okay. Okay, so, I make the motion to approve the variance, and, we have
Based on
item.
the criteria we've identified.
For numbers 1 and 2.
Yeah.
Second.
Okay. And, and obviously, subject to the conditions set out by the.
We're gonna do this twice. This is the first one.
Yes,
Um,
which is
Special conditions and circumstances,
V 1322.
Mm-hmm.
yeah. Mm-hmm.
yeah.
Seconded by Ms. William.
Oh, I already seconded.
Oh, I'm sorry.
Yes, we can vote on it.
Seconded by Mr.
Don't matter who seconded it.
Shields, doesn't matter. So we'll do a roll call on V-13-22.
Chairperson Philippe,
Yes.
Board Member McDermott,
Yes.
Board Member Pierre Lewis,
Yes.
Board Member Shields,
Yes.
Board Member Williams.
Yes.
Okay, and in V-14-22, I made a motion to approve the variance with the same.
Criteria?
hmm?
Criteria?
With the same criteria,
Uh-huh.
and also subject to the conditions as set out by the staff.
Motion made by Mr. McDermott,
Second.
seconded by Ms. Williams. Roll call.
Chairperson Philippe,
Yes.
Board Member McDermott,
Yes.
Board Member Shields,
Yes.
Board Member Williams.
Yes.
And Board Member Pierre Louis.
Yes.
Motion passed for
Okay,
both.
you've been approved.
Congratulations.
Congratulations.
Thank you.
All right.
Um,
Old business, guys? New business?
I got new business.
New business.
Derek, Cameron, I just want to compliment you on how the packets were set out tonight.
Yeah. I agree.
It was really succinct and clear. So congratulations on that modification and doing that. So to you both. And one other personal privilege, Dunia. Hi. For all of those, I think everybody knows Dunia in the back. And she's the one that does all the work with all the screens and everything else. And she was selected as Employee of the Quarter.
Oh, were you now?
Congratulations.
Congratulations, Dunia.
So congratulations, Dunia. That was wonderful. So-
They should send you on a special trip.
Congratulations. She does a wonderful job.
She does.
We're very fortunate that we have the staff that we do here in the city. We have a lot
One of the very rares who stay that long,
you know,
I
huh?
should say. Okay. Any other adjournment?
Move to adjourn.
Okay, thank you. All in favor?
Aye.
Aye.
Next meeting, Wednesday, September 21? Is that correct?
Yes.
September 21st.
Well, I wonder about that.
Yes, I am here.
I think I'm here. Pretty sure.
Okay.
I'm here. Ooh. I signed it for you. Yes, I did. And here's all your extra. We'll just leave that here, okay?
Cameron?
You guys have a good night.
Cameron?